for posting. I want you to just look at this memo under Order 27, Rule 6 of CPC, Your Honor. If this file could be brought up today, I would like to be heard this afternoon, 2:30.
1 minute, please. When was the order passed by the learned single judge?
The impugned orders 14/6/2024, Your Honor.
14/6/24.
Yes.
So why are you so late?
Your Honor, the Honorable Court gave.
Remove the objections.
There is some office objections that I have.
Remove that. You have to take a approval of the committee.
Yes.
Here in person, you will take all formalities, then mention the matter.
Your Honor, there is this memo. I just want you to look at.
All right, please do it.
My lords, it's a fresh writ appeal, my lords. Objections complied, my lords.
Urgency, tell us.
My lord, appellant retired from service,
So what did he pay?
but not settled his retirement benefits for 2 years, my lords.
So what happened to the before the learned single judge?
Learned single judge dismissed the application without going into the merit.
Application or the petition itself?
Petition.
On what ground?
Only alternative.
What was the alternative?
Under 130 of section 130 under the Education Act.
So why don't you go there?
My lords, without the impugned order in the writ petition passed without jurisdiction, my lords.
See, do you have the education tribunal jurisdiction? The jurisdiction lies with that?
No, my lords. It is,
Very well, ma'am, have it after.
my lords, it is without jurisdiction. Passed without jurisdiction, my lord.
The court doesn't have the jurisdiction. Or the tribunal doesn't have the jurisdiction.
No, impugned order before the writ petition passed without jurisdiction.
Objections removed?
Yes, my lords.
Yes, ma'am, tell us.
Grateful, my
My
lords.
lords, this is a fresh contempt petition. The office objections have been complied with.
Please, urgency,
The
ma'am.
urgency is that, my lords, there was a stay operating against the respondents from taking any coercive action in the land acquisition proceedings. Now they have gone ahead and issued possession certificates and allotted lands, my
Just
lords.
take that, ma'am.
Kindly, any date in the next week may be granted.
Just leave it. Just have it next week.
My lordship, this is a fresh matter, my lordship, contempt against the BBMP. They have,
Contempt.
writ petition has been for,
Contempt.
yes, my lordship.
What is the order passed?
It is followed in my favor itself to direct the BBMP to take action. So respondent has filed an appeal there and even that appeal is dismissed, my lords. BBMP has not followed the direction, my lords.
My lords, there was a contempt petition, my lords. The state had given undertaking, my lords, that they will comply with the order within 3 weeks. So 3 weeks have come and gone, my lords.
In which matters?
Contempt, my lords.
No, undertaking is where?
Undertaking before this honorable court, my lords.
What, doing what?
That they'll comply with the learned single judge order within 3 weeks.
Okay.
And the contempt petition was disposed of. And my lords, they have not done so, my lords. So I filed a recall application. And it can come up anytime, my lords, convenient to the court.
Was any liberty granted to revive?
Yes, my lords.
Revive?
Yes.
Take that.
Lordship,
Mr. Tiwari, just take the date.
Yes, my lords.
Lordship, this is a fresh PIL matter. The office objections have been complied with.
What is the PIL about?
Lordship, I'm seeking directions for the respondent to implement there's a guidelines for infrastructure of roads and transport facilities for the disabled people.
Take that. Objections removed?
Obliged.
Yes.
Fresh PIL, Lord, I'm seeking a direction from the respondent to remove the wall constructed by the private company.
Directions against whom?
The flow of Lord rainwater
Direction against whom?
against the authorities. Lord.
Public authority. Just take it. Objections removed?
Lord, they had to-
No, you remove the
2
objection.
days back, Lord, I have filed, Lord, I requested them to.
So
Lord, they said, move the memo.
just take it then. Put out it then. Yes.
Intention of operating against my own mark because that I am not able to use the money.
Where was the order passed?
Bangalore Commercial Court.
So now, what is the nature of the appeal? This is a commercial appeal.
Yes.
What was 39 1 and 2 was rejected? Or did you file any application?
No, that's the time one.
Just take that. Objections removed. See, then it will remain, we get so many objections. Just say subject to objections being removed. Say so.
My lords, fresh contempt matter, my lords. Lords, the Lionel single judge has directed the respondent in this matter, that is the Panchayat Development Officer, to conclude the inquiry against us within a time-bound manner. But even after 1.5 years, my lord, they have miserably failed to do so.
Take that contempt. Louder.
The parties have settled the matter in a writ of it, and same was to withdraw. Withdraw the same instruction.
Just take it after. Just meet next week. Yes, any mention?
Memo for withdrawal. Memo for withdrawal.
No for withdrawal. Is the matter listed today? You want for withdrawal, just take that memo. Yes, call the list.
Serial number
Urgent,
one.
adjournment, serial number 36.
We'll come. Just wait. One.
Serial number one.
Lord, I appear for the appellate. The notice, my lord, has to be ordered on the application, my lord, of conditional delay unless my learned friend, my
The
lord.
objection.
The office objection, my lord,
You have to file English translation. So why don't you file it? And even innocuous order, you are the petitioner there.
no, my lord. I was a respondent management. Management is before the court.
Now, what is the grievance with this order?
No, the difference is that, my lord, the learned single judge, my lord, has relied upon a decision of this honorable court, wherein, my lord, this honorable court has entertained the petition, my lord, in writ appeal. Writ appeals are pending, my lord, in respect of other institutions, my lord, in respect of the very same issue regarding application of section 5.
That's right.
Yes.
So what does section 5 say?
Section 5, according to me, my lord, is repealed.
It's not in existence. What is the nature of 5? What does 5 say? Where is the
Section 5, my lord, is in respect of extension of the monetary benefits to the employees, my lord, on par with the government employees. We are,
Yes, the appeal is pending on this,
yes, my lord.
on section 5. And issue notice, the issue is pending.
Yes.
Look into it. Just say that issue notice. You accept notice for
Not 1 and 2, I shall accept notice.
1 and 2.
2, my lord.
1 and 2. And what about 3, 4, 3 onwards?
My learned friend should appear for respondents 5 to 18, my lord, 5 to 18, though he has filed caveat, my lord, in respect of some of them.
Issue notice to the other respondents.
Well.
Just give a date in August. In the meantime, office objection shall be removed.
I shall do that. I shall do.
18-8. Serial number 2.
Lord, appear for the appellant in this matter.
Serial number Yes.
225 and 46, my lord.
Just 1 minute, Mr. Kumar. In contempt, say just re-notify. Contempt re-notify the same. Yes.
Serial number 225 and 46, my lord, are all arising out of the same order.
225 and 6.
And 46.
46.
225 and 46.
Okay. Now what do you say?
I appear in serial number 2.
Mr. Shetty, it's, you are regulating it.
We are not, there are no regulations to
regulating
regulate
us,
it.
not right.
There are no regulations to regulate it.
Want to?
We don't want to.
There is, I appear, my lord, for the owners and riders. And therefore, in our case, my lord, as a matter of fact, and I'll show you lordships, I don't think there can be any doubt whatsoever that a bike taxi can be operated in terms of, my lord, the statutory framework under the Motor Vehicles Act itself. And there's no
As
existing itself, and that is recognized by the learned single judge and by the division bench of this honorable court. Once that has been recognized, the only real question was to allow us to use our bikes, my lord, as transport vehicles. Because, my lord, there are two things which I have to say. I'm sorry.
These are prevalent in other forms, other countries.
Yes, prevalent everywhere.
So you have applied your mind and decided.
Manoj, it's like this. Manoj. Similar order was.
It's also
Manoj, the short question is, Manoj, without permission or license, can they run as a taxi, Manoj? Insofar as four-wheelers and three-wheelers, they have taken permission and they are running. Insofar as two-wheelers are concerned, Manoj, due to traffic and various reasons, Manoj, as a policy, Manoj, out of 31 states, only 8 states have permitted throughout India. In fact, in Delhi High Court, identical order was passing an interim order, Manoj. Supreme Court said such an interim order cannot be granted.
But that is in the context of.
No, same petitioners. Let me complete it. Okay, then the court has asked me, I'm answering it.
But tell us one thing.
Please, ma'am.
Under the scheme of what is being contended by Mr. Chinnappa is this, under the provisions of the Motor Vehicles Act, they can operate.
No,
It is not such.
it's not such. Not as simple.
Right.
As that. They cannot. Manoj, if that was the case, Manoj, their argument before the single judge was other states are being permitted and we have obtained license. The regulations have been framed in these 8 states. Under those regulations, they have been obtained license.
No.
They had approached.
Yes.
For what?
Your Lordship, prayer is there. Your Lordship may kindly see page.
Lord, my Lordship, may
Identical, Manoj.
possibly serial number 25.
No, it's for the riders.
No, 1 minute.
No, but Mr. Chinnappa, was your petition for a permission or for framing?
No, not framing rules, but according to me, no rules are required. According to me, it is to simply give effect to the provisions of the Act. Because in terms, there are two things which are required, Lord. One is a conversion from a white board to a yellow board, and to grant us a contract carriage permit. A contract carriage permit, Lord, and it's not just this honorable court, but also the central government in the year 2004 itself has said that a motor vehicle, which is a two-wheeler motor vehicle, is entitled to be treated as a transport vehicle. That has been recognized by the division bench. Learned Single Judge also says the same thing and says that it is beyond doubt that a two-wheeler can be used as a transport vehicle.
Not in dispute.
Why the final dismissal?
That Lord, is the contradiction.
Policy matter.
This is a. One second, let me just. You want to?
Manoj, motor vehicles can be used as a taxi, no doubt. The question is, rules and regulations have to be framed as a policy. For example, for regulating, unless we are on a policy, tomorrow, Manoj, we say that we want two-wheelers as a taxi, then it becomes a taxi. Not that they cannot be a taxi, it can. The question is, we have to frame rules and here, Manoj, in Rajasthan, they have,
What kind of
9 states have framed the rules regarding number of vehicles, Manoj. Here, Manoj, 2 lakh trips are made by each one of them, Manoj. There in Rajasthan, one of the permission, only 25 vehicles, name of the vehicles, who can ride it. For example, Manoj, between the pillar, safety measures, all those conditions have been put. Your Lordship may kindly see this, one of the permission of Uber, Manoj.
And this was against the interim order before the Supreme Court.
Yes, Supreme Court vacated the interim.
Court allowed it, saying that you continue.
Yes, Supreme Court said you can't. And interestingly, the same petitioner does not pursue the main matter before the Delhi High Court.
Why is the same petitioner here?
Yes.
Who is the petitioner?
Uber.
In serial number 2, my lord, it is Ola.
No, all of them are there.
No, I am not there. 1 second, I am not there.
You can't go there.
Malord, can I just?
Will issue notice.
No, Malord, can I just clarify? Firstly, Malord, at the outset, the judgment that is now being cited, Malord, is in the context of Malord, the Delhi government framing a guideline stating that you shall not operate Malord, private vehicles without having them registered as a commercial vehicle. Now, Malord, there is a specific rule that the Delhi government has brought about. So there is a policy which is stated, because not under the provisions of Motor Vehicles Act, when they say prescribed means by rules only, and a lot of rules have to be tabled, and there are a whole lot of procedures. So it is not in the state of Karnataka, there is no rule. Now, Malord, when there is no rule at all, may I request Malord to kindly look at page 589. My lord, it is at volume 4 of our paper.
But in any case, Mr.
No, my lord, what I'm pointing out, my lord, is the central government has framed rules. And my lord, the central government rule says, unless the state government decides otherwise, this is the rule. May I request my lord to kindly look at page number 601.
And this was considered by the single judge?
No, but yes, Lord, considered by single judge, but my lord, what the learned judge says is, however, the state government has appointed a committee. My lord, a committee has no basis in the Motor Vehicles Act. The committee has opined that taxis are more environment friendly than motorbikes. And therefore, there is a recommendation of this nature by the committee. And therefore, the state will now have to frame a policy. And if they frame a policy, it is in their purview. I will not interfere with policy decisions. On the contrary, my lord, what we are canvassing is the Motor Vehicles Act has a scheme. And my lord, this, my learned friend also today admits that firstly, under the Motor Vehicles Act, we have to first register a vehicle. Then, my lord, at the time of registration, my lord, the question is whether you are a transport vehicle or a non-transport vehicle, etc. Then, my lord, there is a concept of a carriage permit. That if you are a transport vehicle, I have to be given permit to run it as a taxi, etc. Now, my lord, they were refusing to give this. At which point of time, my lord, we filed a writ petition, came up before this honorable court. This honorable court said, no, the scheme of the Motor Vehicles Act is that motorbikes are also transport vehicles. They also have to be registered as transport vehicles. They also have to be given carriage permits. So do so, make an application and do so within 2 weeks. And my lord, at that stage also, no
rules are required.
No rules are required.
But same
Now,
continuous scheme of these vehicles.
Under the Motor Vehicles Act itself.
The government raised the contention, please do not give a direction, because we just read from para 10 of the division bench order.
We do one thing, we'll set out for hearing, we'll list it. We'll list it on the short date. Yes.
And not for the last 3 years, not there's an intermodal operating.
No, we have objection.
When was the petition filed before the learned single judge?
Well, the petition before the learned single judge was filed on.
Once to reply, just one citation. No,
my lord, the learned single judge has also extended the interim order until Sunday. Disposing of petition.
Just
therefore, Lord, it may be extended by another 2 weeks. Let them file their objection.
just your lordship may kindly just 2 submissions, my lords. Your lordship may kindly see para 10 of this judgment, my lords, because in spite of being the petitioners in this petitioner are the very same petitioners before the single judge, my lords. Para 10. The government of Maharashtra has not formulated any rules in relation to aggregation for the purpose of enforcing provisions under Chapter 5, more particularly Section 93(1). The first proviso to Section 93 stipulates that while issuing a license to an aggregator, the state government may follow such guidelines as may be issued by the central government. The guidelines which have been issued by the central government are persuasive value. They are not mandatory. When the state government formulates in pursuance of its power under Section 96, it may also bear in mind the guidelines which has been framed by the union government in 2020, both in terms of the first proviso to Section 93(1) and the plain reading of the guidelines. It is evident that while these guidelines have to be borne in mind, the ultimate decision to be arrived at by the state government while considering whether to grant a license and regard to formulation. No, therefore, the first submission, what's trying to say that just because there's an act, we automatically run and it is binding on us, has been rejected insofar as very same petitioners.
That's not correct.
Then one other last point, and I'll leave it to that, and then I'll leave it to your lordship. I understand where your lordships are coming. Just one last submission and leave it. Para 3 of the Supreme Court judgment.
Which judgment are you referring to?
Which one? This one.
Which
government of NCLT Delhi, please, my lord.
Give us a copy.
Yes.
Give para 3, my lord. The appeals arising out of SLP number so and so, respondent Rupin Transport so and so, one of the officers who are in present, para 8, my lord. Learned counsel for the petitioner submits the policy is under active consideration. Accordingly, we hereby stay the notice and make it clear the stay shall operate till final policy is if notified. However, once the final policy, if the petitioners are still aggrieved, they are at liberty to take steps before the appropriate forum. Your lordship may kindly see para 4. In the other appeal, respondents are Uber India Private Limited. The interim order is at next page, para 6. Till further orders, no coercive steps shall be taken against the petitioners. This was vacated by the Supreme Court.
But tell us one thing, it appears that is this respondent herein is one of the petitioners appellant here?
Yes.
Ropin Transport.
He was a petitioner before single judge.
No, not here, right?
Not, yeah.
Not here.
Not, no, this, no, tomorrow, the Monday, they were.
Or in Karnataka,
That is in the
They,
context of.
they,
Right,
Huh?
in the context of Delhi.
my,
And para 5 one thing, what is the observation is, the Supreme Court also notes the fact that there are rules, may not be mandatory, but state government has to frame its own rules. Pending framing of the rules, what would be the position?
they can't run, that is what the Supreme Court has said, para 22, para 22.
In this case, rules are framed.
No, rules are not framed, incorrect.
Rules are framed.
My lord, incorrect statements are being made, my lord.
Are you saying
Para
there are no
22,
aggregator
ma'am.
rules?
Under these circumstances, in our opinion, interim order ought not have been passed, staying whole-scale operation of statutory regime till the finalization of the policy. We have already expressed our prima facie view as regards the power of the Delhi government to issue banning orders. Solely on the consideration of balance of communities, such interim orders on a public notice ought not to have been.
And mind it, the Supreme Court has said in the context of government of NCT, which is a union territory.
Doesn't matter.
Saying something in your favor.
Please.
Still, the central government rules which have been framed under the scheme of the Motor Vehicles Act, Mr. Chinnappa, were not made binding on even the union territory.
It's not. We're not even saying that. We're not even saying that.
I think we will list
No,
it.
Lordship, just note one aspect.
Lordship may
This
continue the
judgment
inter.
is on the basis, under section 93, no rules have been framed. On the contrary, Lord, in Karnataka.
Rules are framed. Rules are
And
already.
which permit aggregation. Can you have a look at the rules, Lord? I have produced those.
Have you framed your rules?
Just not-
That those are,
just point out
let them
the
show.
rules, Mr. Raghavan.
Rules are framed.
Let them-
Rules are framed
By the state government?
by the state government, and on the basis of which, not
For
Uber,
four-wheelers,
Ola,
Mala.
all of them are running today. License are issued. Now the question is whether the aggregation rules extends to two-wheelers or not. On the face of it, no, it applies.
The rules say-
On the face of it applies.
Let's narrow down the point.
Yes,
Rules are in place.
rules are in place.
According to him, it's for 4-wheelers. According to you, it should be.
Can you have a look at the rules, Lord? The definition of
The
taxi. just-
the definition of motor
Page
cab.
580.
Definition of motor cab, both under the act and in the rules are the same. Motor cab is anything which carries less than six passengers, which, my lord, is 2 also is a motor cab, 6 also is a motor cab.
So by that implication, you are-
Therefore, this entire argument
By
referring to something
implication, my
else.
lord,
in
by
my
truck
humble
also they
submission-
can get, truck also into the city, my
No,
lord.
no, truck won't be maxi cab. It will be maxi cab.
My lord,
It won't be motor cab. Truck will be maxi cab.
File your submissions.
Please, my lord.
Just say that.
Lakshmi grant the same, my lord.
No, my lord. No, my lord.
What is the difficulty?
My
Mr.
my lord, they are.
10
without-
days.
My lord, by virtue and interim, we filed a vacating stay in 2023. It took nearly 2 years to get it vacated because matter, without license, they are running, my lord,
No,
for
no,
5
yeah.
years. Without permission, by virtue of court, I'm sorry.
See, if this being the position, Mr. Chinnappa, once an interim order it becomes in perpetuity that we.
No, it's still the next date only. We'll make out a case, my lord.
Next date means next date means next date.
No, my lord. On the next date, we'll make out a case. Your lordship may independently examine
We are
it.
ready to argue the case of- we are going to difficulty.
By virtue of court order, they can't run, my lord.
Oh, no. For 4 years, we've been running.
That's the problem.
Now, Lord, in 20 states, they are allowed.
8 states.
That was the
It was a submission by Uber that they started just 1 year ago.
Karnataka should not be lagging back, especially under the AG. Young,
But see, there are two aspects of it. Let's be clear. One, we can say so, interim order continue, but next date it will be vacated. But it gets continued. Or the other one thing is we'll fix preemptorily, the matter will be argued, we'll fix a date and a time also.
Very
By the time you will file your submissions.
Very good.
And it's a matter of few days only, possibly Mr. Kumar, Mr. Chinnappa and Mr. Raghavan. We will not say anything on the interim review.
No, Lordship may say
We
something.
will say preemptorily it will be heard. With a clear understanding, none of the council will take an adjournment.
No, we will
Please,
not.
my lord, that would be better.
But let them not precipitate till then.
No,
What is precipitating, Mr. Chinnappa?
my lord,
Then, my lord, they'll stop us.
my lord,
They'll stop us. If we,
my lord, what is happening, four per day, per day.
4,000 people. My lord,
For livelihood, not that depending on
How many vehicles are there now?
Not about,
Over lakh.
about 52,000.
Imagine the population traffic, my lord, 52,000, my lord, without control,
No
without
control.
license, 52,000.
52,000 rides on booked on the app each day. 4.7
It's huge, my
lakhs
lord.
users
For
are
Uber,
utilizing it.
52,000.
38,000 rider partners with us.
Only Uber is 52,000, my lord.
And my lord, the inconvenience, not only my lord, livelihood of those drivers, inconvenience is public.
No.
My lord, 2 weeks now, all that is saying is,
No.
my lord is fixing the
Last
date.
one,
Well,
Till then,
is recognized by the courts to say.
and my lord,
Same thing before the same.
and my lord, when we.
But just 1 minute, Mr. Kumar. Why is it taking time for you to?
We don't, as a policy, we don't want, my lord,
That
2
they
lakhs,
can't
2
say.
lakhs
That
per
they
ride,
can't do.
my lord.
Then we will have it after 10 days. We will fix it preemptively.
Yes.
Please,
Nothing more interim.
My lord, the question would not be whether they have the power to say so.
We will hear you, Mr. Razvan. If ultimately the court comes to a conclusion, they have framed the rules, those rules need to be read into with regard to these people also. That's a declaration you will get.
Lord Single has accepted it.
But
No,
not
two.
sending
Single
that.
has accepted it in the order.
You'll see that.
But
Not
only-
sending
They
that.
just pointed one observation on the
Lord,
decision of this court.
Why my lord is considering it? My lord, we're only saying for at the most 2 weeks. Nothing, I mean, and this is a.
Well, like Mr. Kumar, we'll see. Today you have a determination against of a London single judge.
Wait.
Himself extended
Can
the
I-
interim order.
Can I, my lord,
Okay, you just say that.
Lord, may I just say one?
Issue notice.
Caveat.
So.
We are on caveat, my lord. You accept notice for all the respondents.
The state must be the only party.
Please, my lord.
My lord, in my matter, there are few office objections relating to form. I will have them corrected.
But you must do it before.
I,
You
we
serve
had
the
it, my
briefing
lord, the file
council.
had come away, my lord.
In
that's
all
the
aspiration, there's union. Is that so?
Just check.
Yes. Respondent file. Respondent.
Just issue notice. And you all are represented by you. only.
No, my lord, except in whole Union of India in
R5.
in Uber's petition.
Who was appearing for Union of India?
My lord,
Who was a learner single judge?
let them serve.
My lord, in fact,
ASG.
Maybe served on ASG, my lord.
To 1 to 4, so and so accept notice. Let
Nayantara was
notice
appearing, actually, not us.
let notice be issued to respondent number 5 to learned ASG. Mr. Adil Kamath, returnable on this with the date.
What is it?
We'll have it on 23rd, Monday.
Lord, till then, my lord, let nothing be done till
We will
then.
not claim equity.
In any event, my lord, it is,
Not to that date.
No,
It is agreed by the council of the parties that they shall file written submissions along with the judgment they intend to rely upon. They also states they shall not take any adjournment on the next date of hearing. We are recording it, we will hear it.
would you,
It is made clear that the appeal shall be heard on the next date of hearing.
my lord, may I?
No request for adjournment shall be considered.
No, we will not make any request for adjournment, my lord, but would your lordship only say that ultimately, my lord, let there be no precipitation till 23rd. Nothing was going to happen till then.
10 days, we will do it. That's the reason we are
Lord.
conscious of two things.
Lord.
One is the source of livelihood. Two, possibly it will facilitate the public transport.
That is true, my lord. Now the difficulty is it's a continuing process which will suddenly come to an end if we don't continue it.
No. See, see,
4 years
we
will
have
not be done it.
We have put a specific query. Possibly if their stand was, we are taking time to frame rules, we will come with the rules. But that's not the case. They say as a policy decision, we have decided not to introduce.
No,
this.
which is,
Raised and rejected by the
We will
division.
hear you, Mr. Rao. If that first one was the possibility, then we could have said so. You are framing rules, the delay is attributable to you. They should not suffer. We could have possibly injected them. But not in this scenario where they have said we have taken a policy decision.
there is no,
They
there
might
is,
be in a better position
My lord.
than if the law were to say you don't have discretion in the matter. At least not-
Mr. Alban. That's the reason with this caveat, we have adjourning it. Mr.
No,
Shetty,
no,
everyone,
we'll not, no, my lord, we'll file it by 20th itself, we'll file a written submission.
submissions 2 or 3 days. days, exchange everything.
We'll do
We will
that.
have it on 23rd, 2:30.
By 20th, we'll file a written submission.
30 p.m.
Please,
Thank you.
grateful.
All the objections, if any, in the appeals be clear before the next date of hearing.
Oh, can it be,
Three
can it be
petitions may be tagged,
24th
my
instead,
lords.
no? I'm so sorry. 24th.
24, 3 minutes.
24, 2:30.
That's right, all the 3 petitions may be tagged. Serial number 2,
Just say that.
25 and
25 and
46
46.
from the common judgment.
It's a common judgment.
As these appeals arises from the common judgment, the learned single judge, these appeals are tagged together to be heard and decided. Next.
Serial number 3.
Just say the big number is 3.1 now. Just say re-notify all. Who is there, Mr. Kumar? You are the petitioner in person?
Yes, ma'am.
We will have it some other day. There is some difficulty for the bench. Okay? Just say that re-notify these petitions on. Just have it after 2 weeks.
7. Serial number 4. Shri Manjunath.
Yes.
Order last time, my lord. The government had undertaken that they will go for some clarification before the children regarding the order. Till date, they have not done anything.
What is this, Mr. Chandrasekhar?
My lords, what happened is this is for the statewide formation of committees for regularization of unauthorized occupants as such, my lords. So there was a generic direction for the state to formulate the committees. So we formulated committees. 1 second in the compliance affidavit, we are given the tabulated column, my lords. More than 20 districts in the state of Karnataka, approximately I'm stating, my lords. So we formulated the committees. So in the Karnataka Land Revenue Act, my lords, as such, there is a bar of distance with regard to the municipal limit and city limits, wherein committee cannot regularize the unauthorized cultivation. So we told where there is a bar, in those districts, we are not going to formulate a committee as such. So compliance report was filed before this honorable court. This honorable court expressed reservations at the initial stage, my lords. Then on 18/3/2025, this honorable court division bench, comprising of the, my lords, puny judge, Mr. Justice M.I. Arun, whose order was under contempt, we were able to convince that our stand is validated. For that, we can't justify the same by means of a compliance affidavit. So we'll go back to the bench which gave the generic directions as such and seek the clarifications with regard to those municipal limits wherein we are unable to formulate a committee because it would give rise to a claims which is not sustainable under law. The court felt, yes, we are justified in such a stand, my lords. But our difficulty was His Honorable Justice M.I. Arun was sitting in the division bench as such, my lords. Now we are making efforts to get the matter listed so that it's heard by His Lordship Justice M.I. Arun, my lords.
How much time you
Finally, 3 weeks time, my lords, because His Lordship is sitting in the bench at Dharwad. So we'll take our necessary steps to seek the clarifications. But 80% of the order we are complied, my lords. There are committees in major of the districts in the state of Karnataka that is on record, my lords.
Mr. Chandrasekhar, for the respondents, states that the clarification as was notified, as was noted by this court in the order dated 18/3/25, need to be taken, for which the matter be adjourned by 3 weeks.
My lords.
Okay?
Very much.
3 weeks.
Finally, my lord, they have not done anything for the last 3 months.
We'll see that. Next.
15/7. Serial number 5.
My lord, I'm the advocate for complaint, my lord. The parties have got the matter referred to mediation, not yesterday.
Sure.
The matter was before the chief
What
judicial
happened?
magistrate.
Not settled.
So my lord, they are trying again. The matters yesterday were again referred to mediation, the matters before the judicial magistrate. And there they have given a.
He again referred them.
Yes, my lord. So the next date in the matter
Right.
30.
Yes. So just say this, though a mediation report has been filed by the Karnataka Mediation Center pursuant to the reference made by this court on 19/11/2024, we have been informed by the counsel appearing for the complainant that the judicial magistrate.
The chief judicial magistrate, Bangalore Rural. my lord.
And just say that, and the said mediation has failed, comma, the chief judicial magistrate has again referred the parties for mediation process. Vide order dated yesterday's?
Yesterday, madam.
13/6/025. Full stop. If that be so, this submission is acknowledged by the learner counsel for the respondent as well. If that be so, comma, re-notify this content petition on, just give it in August.
13/8.
Much obliged, madam.
Serial number 6, Shri Badrinath.
The accused does not complete the office objection from the date of filing the objection.
My lord's compliance affidavit is the successor in interest has filed the affidavit. So my lordships may overrule the same, my lords.
What was that?
My lords, the
Just show us the objection. What is the objection?
the successor in office has filed the,
Oh, okay. But
so it may be overruled, my lords.
we'll implead it, but you should implead him also. Successor must
He is
be-
already there on record, my lords. Because of the transfer, the successor in office has filed the compliance affidavit, my lords.
Just show us that. The successor is also a party here?
No, my lords. We'll, that's the difficulty.
See, you would bring him on record.
My lords.
We will, on oral request, we'll bring him.
My lords,
Shall we do that?
very much, my lords.
Just say that the present contempt petition has been filed against, who is Sri Srinivas, Tehsildar, Bangalore South Taluk. We have been, full stop, we have been informed that Sri Srinivas has been transferred from that post, and a new officer, namely S. Krishnamurthy. That's right, Mr. Chandrasekhar?
Very much, my lords. S. Krishnamurthy, special Tahsildar, my lords.
Mr. S. Krishnamurthy has been appointed as Special Tehsildar, Bangalore South Taluk. On an oral request made by the counsel for the petitioner, we implead Mr. S. Krishnamurthy, Special Tehsildar, Bangalore South Taluk, as the party respondent in place of respondent number 1. As a respondent number 3.
My lords.
As accused number 3, let amended memo of parties be filed. In view of this order, the compliance affidavit filed by Mr. S. Krishnamurthy
May be taken on record.
is taken on record. The objection is over.
My lords.
Okay? This strong.
24/7. Serial number 7, Shri Krishnamurthy. 7.
For accused numbers 2 and 4 in this matter, my lord. My lord,
We'll have it somewhere that it need to be argued.
yes, it requires some consideration and, my lord, in fact, I'll have to file additional affidavit along with documents.
You want to file?
Yes, my
Then the counsel for respondent number
lord. 2 and 4, my lord.
2 and 4 said is allowed 4 weeks to file additional.
My lord, in the meantime, my lord, insofar as A2 is concerned, he is now, my lord, transferred. He is now transferred, my lord, and please.
Who has come in this place?
In his place, my lord, another commissioner has been, chief commissioner has been.
Give the name, everything, we can implement.
Please, my lord. I'll do that. I'll place that.
Next. Next, ma'am.
5-8.
These will all cover 7.27.
Yes, yes,
Till 7.6, it's connected, my lords.
7.6.
You're just passing one order. You intend to file in all the matters, the additional affidavits?
Yes, ma'am.
And you are a common, same respondent?
Same accused persons in all the,
7.4.
yes, ma'am.
Okay.
Please.
Serial number 8.
Issue fresh notice to respondent number 1 and 2.
13-8. Serial number 9. Shinandesh
For the
Gowda.
complainant, my lord, awaiting status of.
Item number 9. Fresh notice to respondent number 1.
12-8. Serial number 10. Kapil Dikshit.
Reading for the appellant, my lords, filing memo for withdrawal, my lords.
You want to withdraw this?
Yes, my lords.
2 sets.
The counsel for the petition appellant has filed a memo for withdrawal. This is as under. The appeal is dismissed as withdrawn.
Serial number 11. Sachin BS.
The objection of the registry on the maintainability of the writ against an order of reputation is overruled. Okay, what has to be done now?
My lord, on the point of delay, my lord, I have filed a, my lord, writ appeal, then.
For 757.
My lord, I have filed a writ appeal, my lord, writ appeal came to be dismissed and directed to file a review petition. Review petition came.
What do you say, ma'am?
He had initially filed a contempt petition, my lords. Later on, when the contempt petition was still pending, they filed a writ appeal, my lords. But,
Then they went to review petition.
my lords, that was subsequent, my lords. We filed a contempt petition after that, my lords, after the writ appeal.
But now they have filed a writ appeal.
Please.
Delay application. They are explaining this is the reason for the delay. You have any objection?
No, lords.
Just say that this is an application seeking explanation of 757 days delay in filing the writ appeal for the reasons stated in the affidavit in support of the prayer and also the fact the learned counsel for the respondents. You appear for all the respondents?
Lord, I appear for
Only
Respondent number 1.
Well,
Respondent number 1 does not seriously contest the application, comma, the delay of 757 days in filing the writ appeal is condoned. Application disposed of with the writ appeal for hearing on.
my lords, may kindly fix a date, my lords.
13-8.
Next.
Serial number.
It's a shorter date, my lords.
This is the shortest.
My lords, it's pending since 2006, my lords. We have,
Here, 13th August. Next.
no, it's a shorter.
It's not possible. Not possible.
Serial number 12.
I appear for petitioner, my lord.
Lord, I appear for the respondent. My lord, copy has been served on the petitioner's counsel, my lord, so the office objections may be overruled.
Yes, my lord.
You have
We have received the copy.
Or the petitioner informs that he has been served with the statement of objections filed by the respondents. If that be so, the objection is overruled. Re-notify the petition on.
14-8. Serial number 13.
For the petitioner in
Yeah.
this case, my lord, I may be permitted to delete the respondent number 11, whereas 11 and 13 are one and same. It has been oversight, it has been.
And the counsel for the petitioner states as respondent number 11 and respondent number
13. 13, one and same. So 11 maybe because,
are one and the same.
yes,
Are one and the same respondent.
yes, my lord. Sundaram Ramaswamy.
Comma, he be allowed to delete respondent number 11.
Yes.
If that be so, amended memo parties, the necessary corrections be made and amended memo parties. Better would be 13.
My lord.
Better would be you delete 13 as 13.
No, my lord, no. 13 is the proper person who is carrying on the mining operation.
Both are safe, you say.
Both are safe. Because what has happened, the advocate for the,
He will tell you the reason.
they filed a wakalat for, my lord, Abhijit Arunalli for R8 to R10, 11 and 13.
He will tell you the reason.
Yes.
You retain 11 as Sundaram Ramaswamy, delete
Yes.
13. Otherwise, there would be a change in the respondent's
Uh,
status.
that is correct, my lord. Whereas the respondents who filed the wakalat, Abhijit Arunalli has filed a wakalat, 13 filed up, except 11, except 11.
We will say so.
Yes.
13 will be treated as for 11.
Yes.
That's
shall be
right.
considered for 11.
The learner counsel for the petitioner states that as respondent 11 and 13 are the same person, comma, he shall delete respondent number 13, provided the wakalat filed on behalf of respondent number 13 be treated as a
Yes.
wakalat on behalf of
Much.
respondent number 11.
Yes.
It is ordered accordingly. Let
Yes.
necessary corrections be made in the memo of parties and amended memo of parties be filed.
I'll file. My lord, state has not filed objection till today. There is an urgency.
4 weeks and 2 weeks. 4 weeks for counter.
One
2
date,
weeks for.
I request you also, date fixed.
11/8.
Oh, my lord, in the, at least next month, my lord, any, because, my lord, I sought for the, because they are carrying on the illegally, they are carrying on the crushing operation, stone crushing operation, that in the land belongs to the temple, my lord.
Okay, 4 weeks for counter.
Lord, the temple has not come forward.
No, I produced the document to show that, that land belongs to the temple.
And temple hasn't come before my lords to say
23/7.
that our lands are being utilized.
Take all your objections, ma'am. Next.
23/7. Serial number 14.
14, we shall do the needful, my lord. In a week's time, we shall do the needful.
What is the R3 for R4?
R3 and R4 is, my learned friend is appearing.
Please, I am not, I am appearing.
You appear for them. Just say that so and so appears, it states that he shall appear for respondent number R3 and 4. You appear for any other respondent?
No, my
No,
lord.
rest of them also.
Rest of them are so. Lord, urgent.
And R4. If that be so, notice to R3 and R4 is dispensed with.
Please.
What will you file?
There's delay application, my lord.
What do you want?
Lord, I have initiated contempt proceedings. Lord, there is an order on, my lord, 21/2025.
Have an objection on delay?
My lord, that is government state appeal, my lord.
By the government, my lord, appeal is by the government. My lord, I have no delay in respect of, my lord, I have no objection to condone. The urgency is this, my lord. Now my 30% of the sites which has to be released by the Planning Development Authority, my lord, has not been released. My lord, there is an order by the single judge. Within 4 weeks from the date of the order, sites has to be released.
Lord,
My lord, there is an interim order passed in the contempt. My lord, kindly refer to that contempt, my lord, order dated.
Lord, in respect of my lord, we have.
My lord, I will submit 1 minute. 21/2025. Lords, in view of the hearing of the petition, it is deferred to 21/2/2025. It is observed that before the next date of state shall ensure the appropriate orders be obtained in the writ appeal, failing which the order of the single judge shall be executed. My lord, this is passed in the year, my lord, on January 2020. My lord, till today, my lord, there is no interim order or, my lord, stay of any proceedings nor implemented the order passed by the single judge. Now, my lord, I am giving before undertaking before this honorable court. My lord, let them pursue the appeal on the merits, my lord. I have no grievance. My lord, I will deposit whatever the demand made by the planning authority to release 30% of the sites before this honorable court, my lord. Let them release the sites, my lord. My lord, it would be subject to the result of the appeal. My lord, by keeping my 30% of sites, my lord, I am not able to answer my claim. The customers, my lord, do you say?
My lord, lordship may kindly have it next week, my lord. We'll go ahead with the matters, my lord, on the merits of the matter.
From September, my lord.
My lord, this request can be considered at that point of time, my lord.
Saying he'll file it, what is the difficulty? We'll have it after 10 days.
My lord, kindly refer. For a moment, my lord. 113, 1 crore 27 lakhs has to be deposited by me to release 30, my lord. That is the demand notice, my lord. 113.
Did you file counter before the learner single judge?
Please,
Yes,
my
my
lord.
lord, they have contested.
Just stand. Why do you want to add on to it?
Lordship may kindly have it next week, my lord. There is,
Just say that.
his request can be considered at the time of admission, my lord. We will.
Lord, I am not able to answer my clients, my lord. The customers who had entered into agreement, my lord.
It has to be heard.
Yes.
You can't hear it today.
Sorry.
That's it. I will have it a day.
Monday, my lord. Monday or Tuesday, my lord. Urgency is there.
We should give a date. We'll give you a convenient date and just show the calendar. Just say that. Learned counsel
He
for
has
the
taken notice.
party states that the appeal be set out for hearing. If that be so, commonly list this appeal on. Fourth of July. 4th of July. Okay.
Please, my lord.
Thank you.
Admission, my lord.
Lord, I'm appearing for the petitioner. Lord, the notice was issued on 28th of February 2025.
Accused is present, my lord. We have filed our objections to the contempt petition.
My Lord, I have one humble submission, my Lord,
Yes.
that the father has not been allowed to meet the child for over 7 months, even when he is having the joint custody of the child.
Which is the order of which you are alleging contempt?
My Lord, may kindly see page number 28, the decree, which starts from page 28.
That's a memorandum of settlement.
Yes, my Lord.
Yes. Which clause?
My Lord, clause 5 at page 29.
Shall have the joint custody.
My Lord, now the issue is, my Lord, that the mother had requested later that the mother had requested that please arrange an accommodation at Pune, as my parents are not taking care of me and they are not able to take care of Vedant, that is the son. And hence the petitioner arranged an accommodation at Pune, and she came to Pune, where, my lord, the child was admitted with the consent of the mother. She has signed in the form also of the admission, which is there in this petition, which I can show, my lord. And thereafter, staying for like some months, when all the fees, everything was paid by the father, my lord, she removed the child without any intimation, and she took the child to Bengaluru, and the father is even not
Where
aware
are
of
you? Where are you residing?
Pune, my lord, Pune.
And this direction or this agreement was to the extent when you both were in Pune.
Actually, the matrimonial place was at Pune, but the mother was staying in Bengaluru later at her parents' place, my lord.
Okay. So what
Yes.
was happening when she was in Bangalore?
My lord, she did not allow the father to meet the child for 3 long years. And thereafter, the litigation, she filed a 498A case also, which was quashed by this honorable court, my lord, on merits.
When did she shifted to Bangalore?
She shifted somewhere 2019, my lord, in 2019.
So what happened between 19 and till date?
My lord, what happened that thereafter, they both decided to settle the matter and close all the litigations among each other. And this matter was settled before this court only, my lord, by WPHC number 41 of 2023. And my lord, thereafter, this matter was referred to the Family Court Bengaluru, which passed this decree on 7th of June 2023.
Where is
And
that? That is the memorandum of settlement.
yes, my lord. Yes, my lord. This is what I am showing. Then, my lord, apart from 5, there are other clauses also, my lord, like clause 11, page 32.
Yes.
The petitioner hereby agrees to keep the respondent informed of the child's educational progress, grant access to his academic records and events, and allow the respondent to attend parents-teacher conferences or other institutional activities. The petitioner further consents to give the respondent all of the educational institution passcode. Then, my lord, also clause 13, my lord, page 34. The petitioner and the respondent both jointly agrees that any major decision to be taken with regards to the minor child, education or medical, the consent from other spouse is must. The petitioner also agrees that any educational
So
or
what
medical
happened?
development.
So
Now,
what
my lord,
happened?
Yes, my lord. Now I am going to straight to page number, my lord, 95. Page 95, my lord. Then what happens, my lord? Then she requests to get the child admitted at Pune, and hence the father got the child admitted at Pune, and he paid all the fees for the entire year with the consent of the mother, because both the parents' consent was required as per the decree. Now, my lord, page 95 is the admission form. This is Asha International School, my lord, which is at Pune, Thergaon Wakad, Rawet, Pune. Now, my lord, she has also signed at page number 98, my lord. Page 98, the first signatory is the mother herself and the father, P.S. Chakraborty. Aparna Banerjee and P.S. Chakraborty both have signed, my lord. So thereafter, my lord, the child started taking the classes in this particular school. And before the final exams only, she took away the child. And my lord, the father had sent a legal notice also to her, my lord. The legal notice also is at page 134, my lord. 134.
No, but what is the contempt?
My lord, the contempt is that she has taken away the lawful custody of the child because it was a joint custody. She is not allowing even the father to have the meeting of the child.
From Bangalore
And
to Pune.
even at Bengaluru, my lord. Even at Bengaluru, because she is not even disclosing the whereabout of the child. Where is the child at present? Where is he studying? Because after leaving the school at Pune.
Just wait a minute. Just wait. What do you say?
My lord, the first point that is to be noted is that the child involved is a special child. It is suffering from autism. That is point number one, my lord. And we have filed for, subsequent to the divorce decree, we have filed for a fresh GNWC requesting for sole custody. And also an execution case because the father has stopped paying child maintenance. In the GNWC matter, my lord, we have filed an IA for temporary injunction, which is allowed, which restrains the father from removing the child from the jurisdiction of Bangalore. The main point here is that, my lord,
that relief has been granted.
yes,
My
my
lord,
lord, the temporary
no.
injunction IA
No, my
is
lord,
allowed.
my lord, that
That is-
was an ex parte order.
Kindly,
1 minute.
kindly
Yes,
allow
1
us to
minute.
submit. Kindly allow us to
1 minute.
submit.
1 minute.
In the very memorandum of settlement itself, the clauses tell that the primary custody should be
But
with the
tell us
mother.
one thing. Even if the father or the child continues to be in Bangalore, but he should have visitation in Bangalore.
Absolutely.
Yes, my lord. I'm just coming to that point, my lord. What happened abruptly? Why the mother is not allowing is because one day the father abruptly took away the child from Bangalore. The child since 2019 till 2023, it was in Bangalore itself. For 4 years, it has its education here. Then the divorce decree happened, memorandum of settlement happened. What happened? One day he abruptly took away the child from Bangalore without informing the mother. The child is a special child, my lord. It is suffering from several medical
So
complications.
now what follows after
What
this?
follows is that, my lord, in the habeas corpus, mother filed since she did not know about the whereabouts. In that, the parties have filed a joint affidavit. In that joint affidavit, kindly turn to my statement of objections, my lord. In that joint affidavit, I
Where
have
was that habeas corpus filed?
just a minute. Habeas corpus was filed in 2023. In that, both the parties entered into a joint affidavit. Page number 122, my lord, of my statement of objections. Document number 22. In that, kindly turn to page 124, my lord. Clause 9. I'll just read that out. The education of Master Vedant shall be at Bangalore. Yes.
Yes.
My lord has the
Read it,
benefit
read
of
it,
papers.
read it, read
Yes,
it.
my lord. The education of Master Vedant, clause 9, shall be at Bengaluru, and the child will ordinarily stay with the petitioner, that is the mother. Whereas Master Vedant will stay 2 days in a week, that is Saturday and Sunday, or as the case may be, as per Master Vedant's comfort. This clearly tells that the child education should be here in Bangalore, because from 2019 the child has been here. But the father is now insisting that the child should be in Pune. My lord, what happened? Owing to this sudden, he took away the child to Pune. Owing to that, the medical condition worsened. That is the reason, only as a temporary
No
arrangement.
objection if he can have visitation in Bangalore in terms of this clause 9, Saturdays and Sundays?
Visitation, we are okay, my lord, but he should not remove the child from Bangalore.
Yes, what do you say?
My lord, secondly, my lord, see, I have certain, my lord, whatever my learned friend has shown, that was in the High Court. But
No.
when the matter was filed in the family court, my lord, in the family court thereafter, it was decided that everything, even the education, medical, everything will be decided by both the parents. Now, my lord, I would like to show one, just page number 58, my lord, for a moment. Page number 58 of the petition.
But is there any order thereafter where the visitation rights have been modified from Bangalore? It has been shifted to Pune?
My lord, there was a clear settlement, deed of settlement, which stated that wherever both the parents will decide, the school, the medical, everything will be, which I showed, will be
It is the
decided by
same
both of them.
memorandum of settlement, my lord.
One minute, madam. So now, my lord, accordingly, both of them decided for the child to be admitted at Pune. My lord, she has herself signed the admission form, my lord, and that is why, my lord. And now, kindly see page 58 for one moment, my lord. Page 58 of my petition.
My lord, there's one more
Page 58.
submission.
One second. My lord, may kindly see page 58 where the mother is writing to the father. Yes, my lord. My lord, she writes.
Which page?
58, my lord. 58.
Yes.
No, my lord, she herself insists that my parents said that they are not going to do a single thing for Vedant. That is the son. She's talking about her parents.
What is the date of this? What is the date? What is the date of this WhatsApp? 26 February, 26 February.
20 February 2000.
Okay. Yes, what do you say? Come now, read it.
Yes,
What are you
yes.
reading?
And I can't stay here as well. I need to look for some alternate accommodation as soon as possible. They are saying, that is the parents, they are saying that they have been doing since 4 years and they can't do it anymore. I will manage everything. Is it possible for you to find an alternative accommodation for me and Bunu is the child? Rest I can manage. Once you get the message, call me ASAP. And accordingly, my lord, he arranges the alternative accommodation at Pune and he pays the entire year fees.
Yes.
And he pays, my lord, the entire year fees in the school as per her consent.
Yes.
Yes. Now, my lord, the decree of settlement of 7th June 2023 clearly says, my lord, that both the parents have to decide together. And I agreed to her demands. I paid everything. I arranged the accommodation. I paid everything. Now, my lord, I have paid the alimony also to her based on all these things, my lord.
Okay. But tell us one thing. This is something which transpired in between both of you now through WhatsApp messages.
Yes, my lord.
Now we are in a contempt jurisdiction.
Yes, my lord. As
Now,
per the
now you come to page, this page.
Yes.
124. 124.
Yes, my lord.
Now clause 9.
Okay. Yes, my lord, this is the High Court. This is the High Court, my lord. This is the High Court order. Thereafter, my lord, thereafter the other order, I am trying to show the decree, my lord, of 7 June 2023, my lord, thereafter. That is at page number, my lord, 28 to 38, in which I have just now showed the clause, my lord. Kindly see, my lord, page 34. Page 34, my lord, of my petition. Page 34. Clause 13, 1-3. The petitioner and the respondent both jointly agrees that any major decision to be taken with regards to the minor child education or medical, the consent from the other spouse is.
That in any case, So on those issues of medical education, everything would be a joint decision.
Yes, my lord.
That's
So
right.
based on that, my lord, based on her own demands, I got him admitted at Pune, and I arranged the accommodation for her. And thereafter, my lord, what has happened that she has not allowed the child even to attend the classes, school.
Where are
And
they staying? Where is she staying now?
my lord, she
Bangalore,
has
my
not
lord.
disclosed clearly where is she staying.
No,
Though
no,
she has
my lord.
mentioned some address,
And where is the child studying?
It is here
not
in
known,
Bangalore, my lord.
not
My
known
lord,
to the father.
the complainant has entered on record in the GNWC matter, fresh GNWC matter, and also in the
My lord,
execution case. In
my lord,
fact, very
after
recently, 1 minute, 1 minute. In fact, very recently, an arrest notice was also issued against the complainant in the execution matter.
because
He had
there,
come to the court. We had a discussion. He even told that he will pay the maintenance. So
my
he's
lord,
well aware about the whereabouts of the child. And about the Pune point that my learned friend is insisting, that screenshot of the message which he's showing, that is not the actual reason.
1 minute.
Yes.
Now today, what will govern? Now, are you concerned with your visitation rights, or you are concerned with the child
my lord,
is still in Bangalore, not in
well,
Pune?
my concern is about the education of the child, my lord, first, whether he is having any education or not, because my consent has not been taken for anything.
But
Secondly,
no, but you are insisting he should be in Pune.
I'm insisting, my lord, because she herself had agreed and I had arranged everything. I had paid everything, my lord.
Very
No,
well.
that was not the point, my lord.
1 minute,
One
1
Yes.
minute,
minute,
my lord.
1 minute, please.
Thirdly, my lord, they have filed this Guardians and Wards Act petition, my lord, by misleading the court without telling all the truth that this has been properly settled
But tell us
and
one thing.
she has been
Yes,
given alimony.
very well. We are in a contempt jurisdiction.
Yes.
Okay. Now, any of the order of the court which has been violated?
Yes, my lord, because I had the joint custody. I do not have even the visitation of the child now. I do
No,
not know
your
where is the child.
visitation, as per this order at page 124, you have visitation on Saturday, Sunday in Bangalore.
My lord, I had also 2/3 of the holidays of the child, which I have not
Very
been
well.
given. My lord, may
Very well.
kindly see, my lord, may kindly
That,
see for a moment page 134 of my petition. For a moment, 134. Please see, my lord.
you don't want to see 124?
My lord, 134, 120. I agreed, my lord. That was in
Come
the
to
High Court.
124 first.
Yes, my lord, that was in the High Court. But my lord, there was certain amendment when it was filed in the family court thereafter in the settlement, and both the parents' consent was required. And my lord, this is why that is why, my lord, I had sent a legal notice to her when she took away the child, my lord. May kindly see just the last annexure at 134, my lord. Page 134.
Page 134.
Yes, my lord.
Now, yes, 134.
Yes, my lord, I have sent this notice on 20th of December 2024. The
You show
relevant
us an order of the court which has been violated.
Yes, my lord, at page
After,
143.
after what happened at page 124, where is the order now?
Yes, I'm showing that, my lord. See, my lord, 124 page is the order which was passed on 29th of May 2023. Now, my lord, after May 2023, both of them appeared before the family court, Bengaluru, and my lord, thereafter on 7th of June 2023, this matter was finally settled.
Where
In
is that
which,
order?
yes, that
Where
is the
is
order
that
I
order?
just showed, memorandum of settlement, my lord, at page number 28.
Page 20 is
Yes.
Yes, my lord, this was passed on 6/6/2023 later, and that is why I'm showing the relevant clause here, my lord, which is para 13, which is just now I showed at page 34.
So based on 13, you are saying you have both agreed that the child will be admitted in Pune school.
Yes,
That's
my lord.
right.
Yes, my lord.
So we
Yes,
take it, you take it, you are not concerned with the visitation rights which continues to be in Bangalore.
yes, but no, but they have not allowed to meet me also in Bengaluru. And my lord, that is why, one second, my lord, that is why I had sent a notice to her that during the Christmas holidays.
So if we have understood you, you
Yes.
want the child should be in Pune.
My lord, at least to complete his academics for which the admission has been taken.
That we will decide it. So we
Yes,
take it you don't want visitation in Bangalore.
my lord, I want, because till the till the time this matter is decided, my lord, I should have my visitation at least of the child.
Who
Because
is
I'm more
denying you visitation in Bangalore?
yes, and
Denying visitation.
No, my lord, for Saturday, Sunday, he can come visit the child, but he
no,
should
my lord,
not take the child out of Bangalore or out of the house
my
because
lord,
he had done that last time. It's a special.
1 minute, my lord. It is not only 1/3. It is not only Saturday, Sunday, my lord. It was also decided that 2/3. My lord, may kindly see page 125 of the reply, my lord.
Whatever is the joint affidavit, whatever
Yes,
is
yes,
the joint affidavit,
yes.
that will be complied by both of you.
Yes, my lord. Now I am showing the same order what my learned friend is trying to show. That is at page 125, my lord. The next
Yes.
page. She is showing 124. I am showing 125. Para 13, my lord. Para 13.
This is about the vacations, my lord.
125. Page
There's no
125.
vacation now. The child is going to
Minute,
school.
madam, 1 minute. Let me just read
Page,
it out.
which page?
125,
Page
my lord.
125, ma'am.
Of the
Objection.
objections.
Yeah, we spent 2/3 of his beginning vacation with the respondent and 3 and 1/3. Now vacations
Yes,
are still
yes.
No,
continuing.
no, my
My
lord. The
lord,
child has
she
been
has
admitted to
refused.
school
My
here.
lord, 1 minute, madam. They have completely refused to send the child for the vacation. And that is why I had sent the legal notice, my lord. And I was trying to show page 143 now, my lord, for
See,
a
the
moment.
difficulty is this. You insist in Pune, they insist in Bangalore.
No, my lord, even for the holidays, they refused. At least holiday was my right to have
That's
2/3 to spend with my son. I have
Now,
paid the alimony also, my lord, based on all the settlement.
very well. These vacations are over.
Yes, my lord, it is over. And
Yes, my
mother
lord.
has the primary custody even as per the memorandum of settlement.
My lord, may kindly, for one moment, for the sake of justice, my lord, may kindly see page 143 of my submission, my lord. 143.
Yes.
Yes. 143 to resume his school thereby at Pune within 7 days hereof. And also, it is imperative to mention
Just
here.
1 minute, please. 1 minute.
Yes. One 143 of my submission.
Yes.
Yes, my lord. Here I had sent the notice. I had mentioned that to resume his school and therapy at Pune. Therapy is, my lord, the medical. Therapy at Pune within 7 days hereof. And also it's imperative to mention here that our client reserves his right to spend 2/3 of Master Vedant's vacation period with him, as clearly stipulated in the settlement agreement. And hence, our client in any case would like to spend 2/3 of the coming Christmas holidays with the child. By failing to adhere to the terms of the settlement and by obstructing our client's rights, you are in violation of the court's order. And under
Now,
PMP,
just listen to us. Now,
Yes, my
if
lord.
you were to get the visitation in terms of this clause, 2/3 of the, vacation, you would have had the visitation in Bangalore or Pune.
My lord, it was something that 2/3 was to be spent with the child at Pune.
How do we get that?
My lord, it was mentioned that there was no any, my lord. Otherwise the father cannot.
See,
My
you
lord,
have to read it in a context.
yes, my
That
lord.
context is this.
My lord.
Saturday, Sunday, 1 minute, you will listen to us.
Yes.
Saturday, Sunday, Bangalore, father will have visitation. In continuity during vacation, this is the arrangement.
Yes.
So it must be read to mean in Bangalore, not in Pune.
My lord, that Saturday, Sunday was in Bangalore because the child at that time was studying in school. Now,
Very well.
yes, but what happened? 2/3, my lord, now 2/3, my lord, if he has to spend only in Bengaluru, it is first of all nowhere mentioned that he has to spend 2/3 in Bengaluru. And my lord, in that case, that father cannot take the child for so many visitation, tourism places and for any other places where the child would like to go with the father. So that is why, my lord, there was no restriction of the jurisdiction to travel with the child.
Just few humble submissions, my lord. I will counter that Pune
1
point.
minute. Not like this.
Please, madam.
Where is that 2/3 clause?
My lord, at page 125 of their submission, para 13. page 125 of their reply, and also it is mentioned in the later order, the decree which was passed by the family court.
Okay, okay. Now read in context. Come to page 124. You have seen 124?
Yes.
That's in Bangalore. Education of master shall be at Bangalore.
At that time, before the further orders, yes.
Then in continuation, what decided is at 13. Now, where is said in clause 13, it should be in Pune.
My lord, we are, my lord.
Where is it said it should be in Pune?
That is why, my lord, see, my submission is, my lord, that when in May 29th May 2023, when this order was passed by the High Court, it was clearly mentioned that 2/3 time will be spent by
All right,
the.
we have put the question. We have understood that. Where is the
Yes.
clause which says 2/3 should be in Pune?
My lord, it could be anywhere because the father has to
Don't
take
say
the child
anywhere.
for visitation.
Don't say anywhere. The choice is
Lord,
between Bangalore and Pune. Pune doesn't find mention in clause 13. 9 is very clear. Saturday, Sunday, you would be here. And mind it, see clause 10. Ultimately, the interest of the child is paramount.
That is, my lord, as for the interest of the child only, my lord, the child has to travel and see at least the
Okay.
country.
You want the visitation in terms of clause 9 or not?
My lord, now, my lord, may kindly see the further order at clause 9 only, my lord, of my submission. This is the final order which was passed by the family court.
Which
my lord,
page?
May kindly see page number, my lord, 31.
Yes.
Yes. Here at para 9, my lord, it says the petitioner and respondent agree that the minor child will spend beginning 2/3 of the vacations with the respondent and remaining 1/3 with the petitioner. The respondent further agrees that while the kid is in his custody, he will assign a therapist for the minor child since the child has special needs and requires daily special care and therapy in addition to being taken care of in accordance with his daily routine and prescribed sleeping hours. The petitioner will have complete liberty to see the minor kid at the respondent's location in the event of an emergency. So, my lord, respondent's location is at Pune. Respondent's location is not at Bengaluru, my lord. Page 31, my lord, of my submission. It is clearly mentioned. Page 31, my lord.
That is during vacation.
Yes, page 31. Page 31, there is the petitioner and respondent agree that the minor child will spend beginning 2/3 of the vacations with the respondent and remaining 1/3 with the petitioner. The respondent further agrees that while the kid is in his custody, he will assign a therapist for the minor child since the child has special needs and requires daily special care and therapy in addition to being taken care of in accordance with his daily routine and prescribed sleeping hours. Now, my lord, the next is very important. The petitioner will have complete liberty to see the minor kid at the respondent's location in the event of any emergency involving the minor child's health. So, my lord, the respondent's
That is during vacation, my lord.
respondent location is at Pune and not Bengaluru.
Just 1 minute. Where is the No, this is of 6th of June. And this is and this is earlier. Now this memorandum is of 6th of June.
Yes, my lord.
Please, my lord. They agree through this memorandum of settlement, they agreed to withdraw even the habeas corpus petition. In that joint affidavit is filed. Everything has to be read together. It's not separate arrangements, my lord.
The memorandum filed before the family court.
Family
Years
court.
later.
Yes, before the family court. That 125 page number which I was talking about is the joint affidavit in the habeas corpus matter before the Honorable High Court. Even in this memorandum of settlement, my lord, they have agreed that they will withdraw that habeas corpus matter. So to that effect, they had already entered a joint affidavit.
My lord, habeas corpus was filed
1
by
minute,
them.
please. You will not interfere.
I'm sorry, my lord.
Now tell us one thing.
Please, my lord.
There is a change circumstance. This memorandum of agreement which was executed on 6th of June.
Right, my lord.
It doesn't refer to the visitation in Bangalore. It doesn't refer to.
What it says is that, my lord, the primary custodian will be with mother. So
Forget
mother
that.
is in Bangalore.
But in clause number 9 of the memorandum.
Clause number 9 is exclusively talks about vacations, my lord, because the mother was here. After separation in 2019, she came to Bangalore with the child. Till 2023, mother and child were here. So after, and the husband was in Pune. So that clause 9 is about vacation.
Yes.
Yes, my lord. During vacation?
If the child is with the respondent husband.
Correct. Yes, my lord.
Mother can go to that place where the husband is residing and meet the child.
Please, my lord. That was exclusively during vacation. Yes, my lord. Please, my lord. But one submission I would like to make, my lord, the Pune point that my learned friend is emphasizing. What happened? I just said that the child, he abruptly took away the child and we filed for habeas corpus. Subsequent to that, several medical complications happened. That's the reason, in the interest of the child.
We will not go beyond this. Now, has it been agreed that it would be in Pune? He can take the child to Pune?
Nowhere it is mentioned like that, my lord.
But how would you reconcile that 29/5 which was executed or which was agreed to and this 6th of June? 6th of June doesn't refer to any Bangalore at all. And it talks about location, husband's location. Why is the husband's location?
That is only during vacation, my lord. Why it doesn't talk is because.
Wait a minute, 1 minute.
Primary custody.
1 minute, please. You agree that insofar as vacation is concerned, it's in Pune? You agree there?
For 2/3.
That's right. So it's in Pune.
Please, my lord.
Okay, so that's like
during vacation.
So very well, we'll take it. So it's the vacation. It's in Pune. That's your case also. So what he's saying is, so 2/3 Pune, he will have the right. Now, when it comes to Saturday, Sunday, does it say? It says Bangalore. It
Please,
doesn't say otherwise.
Please, my lord.
That's right. And this 6th of June doesn't really refer to.
Please,
Just
my
wait.
lord. But what happened in Pune?
1 minute. 1 minute. Now tell us one thing. What is the name of the council? Huh? Yeah, Mr. Srivastav, just tell us this.
Yes, my lord.
Yeah, just tell us this. So the visitation would be in Bangalore on Saturday, Sunday. That's your case?
Yes, my lord. As I mentioned, my lord, I see, my lord, the father is not interested
Yeah,
to have
just
any
asking a specific for visitation on Saturday, Sunday is your Bangalore visitation?
Yes,
or
my lord.
no?
Before the child was admitted at Pune, yes. But after the child was already admitted at Pune with her consent.
So you are agreeable for visitation on Saturday, Sunday at Bangalore?
Yes, and the vacation at Pune, my lord.
And vacation at Pune?
Or wherever the father might be shifting because it is his transferable job.
Very well.
We do not agree to that, my lord, because when the child was in Pune, its medical condition worsened.
Wait. For time being, we will say, for time being.
Yes, my lord.
You will listen to us?
Yes, my lord, listening.
For time being, whatever is the requirement, visitation at Pune, that will continue.
Yes,
if you want any variation insofar as your location is concerned, possibly you may have to come back to the court and then seek this thing. So we can say this only on 2 things we can record. Ma'am, you must take instructions.
Please, my lord.
Visitations in Bangalore on Saturday, Sunday.
Please, my lord.
Vacations 2/3 at Pune.
At Pune, why not? Is because, my lord, when the child was in Pune, its medical condition worsened. And even though the father, he insisted for homeopathic treatment, and that became a big disaster.
Let's not go into that. We are only what has been agreed. We are seeking implementation of that.
Please, my lord.
That's all.
The first condition, we are okay with that, my lord. Saturday, Sunday
You
visitation.
will not have a choice. Let's be very clear. We are just only putting it to you. If you are agreeing, we'll record your agreement.
Please,
That's
my lord.
all.
Please, my lord.
You agree for that?
The first one, yes, my lord.
You are on second one.
We would require instructions for that.
Take instructions. We'll record it.
And one more, my lord, humble submission, my lord. And one more, my lord, humble submission. My lord, may I make one humble submission, my lord?
Just 1 minute. We'll come back. Just one. Yes.
The point is that, my lord, when the child was in Pune, the medical condition worsened because he started homeopathic treatment.
We are with you on that.
There's a change of circumstances now, my lord. That's the reason.
What are the change in circumstance?
This is the change of circumstance, my lord. Here,
Now,
there.
were you not required to seek modification of this order?
Yes, my lord. That's the reason I have filed for a fresh GNWC matter. In that he has filed his wakalat, and in that there's an
That's
injunction.
the ground. This is the ground.
Yes, fresh
When
GNWC
is the
matter.
date?
The GNWC, my lord.
We take it. You have sought the variation in the agreement, whatever understanding you have arrived at by
Yes.
filing a fresh application.
Fresh, yes, because
And more particularly with respect to your visitation rights, his visitation rights during vacation,
please, my lord.
not on Saturday, Sunday.
We are requesting for sole custody. The whole agreement we are asking for a change as far as the child is concerned. Because this agreement was completely about joint custody. But now we are asking for sole custody and permanent guardianship.
And including variation in these orders.
Yes, my lord. I have attached my petition and also certified copy of the order sheet in the
When
fresh
is the date?
GNWC
When is the
matter.
date?
My lord,
Just a minute. I have filed it on January 6th, January
What is the
2025.
next date of hearing?
Next date.
Next date of hearing, it is in August, my lord. It is in August.
Yes. Now say, tell us one thing. Is there any application which has been filed by the other side before the court for variation of these orders and whatever agreement has been settled between both of you?
my lord, first of all, my lord, this was settled in the High Court only, my lord. And then this
So that's
matter,
right. In any
my lord,
case,
my lord, I have, see, my lord, as father has already paid alimony, everything he did as per the settlement.
okay.
Now she is going
Just
back
1
on the
minute.
settlement.
Just 1 minute. Would you be agreeable? At least being a father, he should have at least some
We
visitation.
understand that, my lord.
The date is in August.
Please,
My
my lord.
lord, my lord, as of now, since this order has been passed by the High Court, my lord, and they have filed a separate petition which will have its own merit. But as of now, whatever the order has been passed, that has
You
to be
would allow
complied.
us to complete it. You would allow us to complete it.
I'm sorry, my lord. I'm sorry.
What we are putting it to you is this. Till such time the August is the date, you will allow the visitation on Saturday, Sunday of the father.
Please, my lord. But he should not take the child out of Bangalore.
What do you say on that?
My lord, then, my lord, the entire settlement which took place has got no meaning then, my lord.
Okay, then we will hear you next week. Not today then.
Then, my lord,
Just
my lord, my humble request, my lord, interim may be passed and then this matter may be kept for further hearing, my lord.
No, nothing of that sort, please. We will have it next week.
My lord,
So we take it you don't want visitation even on Saturday, Sunday.
I
as
want, my
agreed
lord,
to.
I want, my lord, let this matter
what?
be kept pending with this order.
So what
And
we are saying is this, without prejudice to both the parties, application is pending. You will make all your submissions. We will record her statement that the visitation on Saturday, Sunday, as agreed to, would continue till the next date of hearing. Now, the only
All right.
case would be of vacation.
Yes.
Till August, there would not be any vacation. It would
Yes.
be inconsequential.
there,
We say
there
anything
could,
on that.
Till October.
there could be some holidays, but not very long holiday. I do understand that.
Vacation. So better, see, ultimately he's a child, he's a special child. You should not even also, as a father, surely you will be looking in that perspective also. So we will only say so. We will record her submission. Saturday, Sunday, you will continue to have the visitation.
At the house of the mother, my lord. Because again, if he takes the child to Pune and it's a havoc.
No, my lord.
That's the
No,
reason
not
we
at, not
got
at
the
the house, my
CI
lord. It
also.
will be uncomfortable.
That fear is because last time he did it. my
You
lord.
are adding on to it. Where does it say it's at mother's house?
Nowhere, my
Yes,
lord.
my lord, because now there has been a change of circumstances.
We will not allow that till such time that application is decided.
Please, my
Let the
lord.
learned judge apply his mind and decide it.
Please, my lord.
We will not modify, vary what has been agreed to. We will be recording what has been agreed to between the parties, that will be given effect to.
Please, my lord. But
Saturday,
TI
Sunday.
says that out of Bangalore he cannot take.
But tell us, what do you say on you will not take the child outside Bangalore?
My lord, then, my lord, when the matter is pending, then she is trying to get the issues decided, which is not going to be decided now.
We are not deciding it. Let's be very clear. The court will not pass any order.
And my lord, one small submission, my lord, that she has not been telling about any medical assistance of the child which I was taking care of at Pune. And my lord, as per the decree, I should have access to the child's medical checkup also, my lord. And that should also be allowed as the decree states so.
My lord, this is a contempt jurisdiction. There is no willful disobedience of the order.
He himself
Absolutely.
is admitting that.
So today there is no vacation till August. We say nothing. Okay, and we will record her submission only, visitation on Saturday, Sunday as agreed to at page
124. Page 124, my lord. Visitation.
124 of the objections.
Yes, as per page 124
of the objections.
Yes.
You have seen that?
Yes, my lord.
So we will be recording her submission that you will have the visitation on Saturday, Sunday. In
Yes.
terms of this clause 9.
Yes, my lord.
Okay.
Yes.
The child is taking therapy here, my lord.
And mind it is as per his comfort. Okay, so we'll dispose of the contempt. Rest we say nothing, you will work it out before the court concern.
Please, my lord.
Yes, my lord.
No, my lord,
There's no willful disobedience,
my
my
lord,
lord.
then, my lord, let this matter be pending, my lord. Let this matter be pending because, see, the matter has already been decided and settled. It will be a new chain of litigations, my
Then the
lord.
court will not decide the application. The lower court need to decide now, let it apply its mind.
My lord,
Without being influenced any pending here.
my lord, then if this matter is disposed of, they will never allow me to have the visitation if this family matter is not decided. My lord, my contempt started much before that. The Christmas holidays, she has not allowed me. The summer
GNWC, we filed before contempt.
Just say this, we have heard the learned counsel for the parties for some time or at length. It is agreed by the counsel for the parties or by the counsel for the parties by drawing our attention to page 124 of the objections filed by the respondent herein on 26th April 2025, which reads as under. Just rephrase it. It is agreed by the counsel for the respondent that as agreed by the parties at page 124 in terms of clause 9, which we reproduce as under, comma, the petitioner can avail the visitation till the next date of hearing. We will list this petition in July.
But he should not take the child out of Bangalore, my lord. It's better if he comes to the house and... Please, my lord.
Till the next date of hearing, we will have it in July, this petition. You have the visitation on Saturday, Sunday, as per clause 9. Okay?
Obliged.
But you will not take the child outside Bangalore.
Yes, my lord. Yes.
The counsel for the petitioner is agreeable to the aforesaid position. He also makes a submission on instruction. Oh, hope your client is there with you.
Though the client is not here at the moment with me, my lord.
We want you should, we will be recording your submission. We are taking it on record. And possibly you may have to file an undertaking before this court.
Please, my lord.
So take instructions. You can take instruction in 5 minutes, take it. Otherwise, we'll simply re-notify in July.
All right, my lord. All right. May I
What
be
do you
given
want?
5 minutes? I will take instructions.
Yeah, just come back after 5 minutes.
All right, my lord.
Please, much obliged.
Next.
16, government advocate.
We'll have it some other day.
Service
We'll
of
have it
notice
some
on
other day.
R4 and R9, my lord.
What is the matter? Issue
Service of notice to R4 and R9, my lord.
1 minute. R3 and R4, na?
R4 and R9. R3, 4 and 9.
R3, 4 and 9, notice. Next.
18-8. Serial number 17. 17.
Okay, for the petitioner. You have not filed your reply?
Well, sir, we have issued an endorsement on 21st of February 2025. I'll share an additional copy.
Just give it to him. Mr. Chandrasekhar has given a copy of the endorsement.
Very much.
Showing the compliance of the order.
I will just reply. It's a compliance only.
Compliance of the order of which contempt is alleged.
Very much.
To the learner counsel for the petitioner who seeks some time to look into the same.
Please, I'll take it section.
23-7.
Grateful.
18. Serial number 18.
Respondent has to file report.
You have to file. Who has to file?
Mr. B.L. Sanjeev appears for the respondent.
Just say re-notify. We'll have it some other day.
Please.
Just note.
4-8. Serial number 20.
Well, sir, this morning we have preferred writ appeal. We have e-filed the writ appeal.
19.
Mr. Chandrasekhar says
My
that the
lord,
writ
I am
appeal.
for the appellant. Compliant. Respondents have not complied the order
They filed a writ appeal.
because it is to consider representation, my lord, for mutation record. That is.
It's all right. They have filed a writ appeal, but it's only for consideration.
Yeah, yes, sir.
My lords, the grant is in dispute.
More than 9 months lapse.
The grant is in dispute, my lords. It's the fourth grant.
Just say that Mr. Chandrasekhar says that the respondents have filed an appeal. Let a copy of the appeal be given to the learner counsel for the
Short date may kindly be given.
re-notify on.
18-8.
Just give a copy of the appeal to him.
Morning we e-filed it, my lords. We'll serve a copy
I'll
also.
just give him a copy. Next.
Serial number 20. Shri Devraj.
20, 24.
20.
20, we have served the learned counsel as directed.
Pardon?
The Honorable Court had directed us to serve the counsel who had appeared before the learned single judge. He's appeared today. So the respondent is now represented. There is a delay, of course, my lords.
Who appears for one? One is
My lords,
appear?
myself, my lords. In 20, I appear for 20 and 20.2, I appear for counsel. And in 20.1, I am one person.
Okay, we can post it for hearing or anything urgent,
So
Mr.
my lords, some urgency, but if the delay could be condoned in the meantime, because I'm sure that.
My lords, only one point, my lords, only one short point is that, my lords, by virtue of RERA order passed in 2018, my lords, on my complaint to refund, I was refunded in 2018, October. And he did not comply it as per section rule 17. Within 60 days, he had to pay of RERA rules, my lords. And he did not pay. RERA had to take all steps and we had to saddle
Just say that.
without money.
You have any objection on the delay?
Delay, my lords, I do not have, my lords.
Just say that this is an application seeking 200 delay, condonation of 216 days delay in filing the appeal for the reasons stated in the affidavit in support of the prayer, and the learner counsel for the respondents do not seriously contest the application, comma, the same is allowed. The delay is condoned, application disposed of. Just say that re-notify on.
Lords, can it be had on some earlier date, my lord? Because my second application for compensation, my lords, he paid the amount after 8 years and we were having bank loan.
This first week.
I'm sorry, my lords.
4-8.
July first week would be our summons. I think both sides, it is a short point. I'm in agreement with my learner.
Very, very short.
See any July.
Let's take on.
Because on that ground that my lords, writ appeal is pending, proceedings have been held.
17th of 17/7. Next.
21. Shobhit Shetty. 21.
Just re-notify on.
4.
Re-notify, we'll have it some other day.
14-8. 22. To be a
Yes, Mr.
That's this is a matter.
Serial number 22.
I can go
None.
there.
You are for the respondent?
Yes, yes.
If they want me to go there, I will go there.
I think it's the Mr. Murthy. Mr. Murthy. What is the contempt alleged? At the request of counsel for the petitioner, re-notify.
Office objection may be overruled, my lords.
What is that objection?
That objection is at the time of verifying the petition, there was one officer. Now who has verified is another officer. That officer has left the company.
But the only thing, the new officer must come on record.
Yes, he has come.
He has come?
Yes,
Verified the affidavit.
he has verified the affidavit.
No, no. In the memo, Mukund Vasudevan has been transferred.
It's transferred.
Who has come in place?
HR has.
Managing director is Mukund Vasudevan. HR officer has signed.
So then Mr. Vasudevan would be the respondent who would be on record. If anything contempt alleged, contempt found, it would be Mr. Vasudevan.
Yes, my lord. Yes, correct. Because verifying affidavit is by the HR.
ಯಾರು ಮಾಡಿದ್ದಾರೆ?
Mr. Murthy, it's simple.
No, no, what? Yes, my lord.
If any contempt ultimately found,
Rajesh.
then it would be Mr. Vasudevan.
Very well. But I thought
Record.
normally the managers sign for the company because they are authorized by board resolution.
That's why we take that.
Oh,
We take that. But contempt, this gentleman.
Yes, yes, my lord, yes, my lord.
At the request of counsel for the petitioner, adjourned to, insofar as the objection put by the registry is concerned, Mr. Mutil and the senior counsel for the respondent states that it is only the officer of the company who has verified the pleadings, verified the averments made in the compliance affidavit.
In the repetition.
He states that no amendment is required to the memo of parties, as Mr. Mukund Vasudevan, the managing director, is a respondent. He is a respondent against whom the contempt has been filed.
But even in the petition, it was only the officer who had signed.
We'll see. Next.
5-8. 23, Shri Sampath. 23.
My lord, appearing for the appellants, my lord. My lord, in this matter, the notice to respondent number 4, who is the Deputy Commissioner of the KIDB Regional Office, has not been served. I may be kindly permitted to serve it on the learned counsel BB Patil, who is the panel counsel for KIDB.
Respondent number 4, you said?
Please, my lord.
Notice to respondent number 4. Additionally, liberty is granted to the counsel to serve the, who is the?
BB Patil, my lord.
PB Patil.
Please, my lord.
PB Patil, he appeared for respondent number 4.
He appears for respondent number 4, my lord. He's
PB
the
Patil.
panel counsel for KIDB.
The panel counsel for KIDB.
Yes, ma'am.
That's right, KIDB. Next.
Much obliged.
18-8. Serial number 24, government advocate.
There are certain
Yeah, for
office
the
objections, my lord,
respondent,
in
my
the
lord.
appeal.
None for the petitioner adjourned.
My lord, it's government appeal, my lord.
Oh, it's
There are
your
certain
appeal.
office objections, my
Lordship,
lord.
can-
We'll clear it in a week's time, my lord.
Your Lordship, kindly contempt petition ordership dated 27/3/2020.
What has to be done?
You must be complied the
What are the direction? What compliance?
Podi and Durast work, my lord.
What is the
Since
difficulty?
2 years elapsed, my lord.
But tell us one thing, you get your writ appeal listed, na?
There is a condition order.
My lord, we
Get
had
your
filed a
writ appeal.
review, we had filed a review petition, my lord. Our grievance was very limited, my lord. The learned single judge has directed us to consider his representation by relying upon a sketch, my lord. There were certain defects in the sketch. We were willing to consider
Yes,
the
yes.
representation and take a decision, my lord. The order of the learned single judge that it should be considered by relying upon a sketch came in the way, my lord. We sought for review. Review came to be rejected on the ground of delay, my lord. Therefore, both orders of review as well as
Then
the,
list after 2 weeks. We will look into your,
please, my lord. Only limited extent we are seeking
Already
indulgence.
2 years is over, my lord. There is one or the other reason they are taking time and drag on the proceedings, my lord. Only Durast, all the revenue records standing in my name, my lord. Yeah, everything is completed. Only Durasta code work has to be done. my lord.
You are right, but there is a writ appeal which is pending. We have to decide that.
There is no interim order in the writ appeal, my lord. There is a number of objections is raised by the writ appeal, my lord.
Into
Even
it.
today, they are not.
We will look into it. First, we need to decide the appeal. We will decide it, appeal nahi, then we will go into contempt. Both are listed together. We'll decide it, appeal. We'll have it after 2 weeks.
Earlier occasion, there is a condition, there is an order by the Supreme Court, my lord. On 27/3/2020.
Just 1 minute. In
Please.
the meantime, objection shall be removed.
Please.
Have it after 2 weeks.
Please, a date may be given, my lord. Otherwise, it will not
Yes.
come. Short date may be given,
After 2 weeks,
within 10 days, my lord.
After 2 weeks.
8/7.
Next.
8/7 long date, my lord.
Issue of maintainability, my
Within 10
lord.
days or 15 days, my lord. There is an urgency. 2 years, 2 years
Right,
elapsed.
See, board doesn't permit. We are giving you the first week. We are giving you a short date. Okay, next.
My lord, regarding the maintainability, my lord, we have challenged the order of review, my lord, along with the writ petition.
That,
It
I
has
think
merged with that, my lord.
Objection would not sustain.
Please, my lord, that's why, my lord. Rest of the
Filed
things
a
will
writ,
comply.
He filed a review.
Please.
Against writ appeal is maintainable. With review, it will not be maintainable. That we can't accept. Just say this.
But for that, we will comply rest of
The
the.
writ, insofar as the objection on the maintainability of the writ appeal to challenge an order of the review petition is concerned, the same is overruled.
Please.
Next.
25 adjourned, 26. 26.
For the respondent number 5 and 6, pray for a time, my lord.
Re-notify on.
My lord, I take notice for respondents 1 to 3. Though they are served, my lord, they are unrepresented, they may not government officials, my lord.
It is a suo motu case, my lord.
26.
26.
26 suo motu, it's a PIL, ma'am.
Yes, my lord, I'll take notice.
No, this is a 2020 petition. But notice has not been issued, accepted.
The notice has been issued, served, they are unrepresented. Since I represent the government, my lord, I take notice of.
Which
them.
respondents?
1 to 3.
1 to 3 not accepted.
State of Karnataka.
We'll just tell you. 1, state of Karnataka served, 2 served, 3 served, 4 served.
Yes.
So we will only record that you will appear for them.
Yes.
1, 2, 3, 4, so and so appears. Next.
6, 8. Serial number 27.
This matter, Lordship said heard relating to Rule 7. Deemed.
One submission before my learned senior begins. My lord, they were relying, they had filed an application, my lord, I had requested for a copy. Till today, that copy is not given. my
What
lord.
copy?
My draft
But I don't know what my learned friend is saying. Last time, Lord, some other government advocate appeared.
he's here.
1 second. Let him permit me to complete. But then they sought time. Lord, I pressed for an ex parte ad interim order. They said they will look into this Rule 7 and then submit before your lordship. For the first time, government comes up and says copy is not served upon us. Kindly look at the acknowledgement we have to show that they have been served. Now, my lord, in short, my lord, I want to bring to lordship's notice this. My lords may kindly consider. Lord, kindly look at the action of the government. Lord, without notice to me, they have stopped my mining lease, where the law expressly states that it is a deemed extension. And this is the latest endorsement, they themselves give it.
My lord,
One
I'm
minute,
sorry,
ma'am.
my lord.
Just 1 minute. We will have it on Wednesday. Re-notify on Wednesday.
My lord, could I have my lord, my draft is ready. If they serve a copy of the the application, my lord, I'll file objections to
When
that.
will you file it? Tell us.
My lord,
What is the
draft is
minimum
ready.
time you require?
My lord, let the copy of the application be
Give a
served. I
copy.
don't have it, my lord. Why will I make a incorrect submission? I don't understand.
No.
Have you served a copy on her?
My lord, I asked my learned
1
friend
minute,
also,
ma'am.
my
Just
lord.
1 minute. Not like this. Have you served a copy?
My lord, prior to filing itself, it was served on the state, my lord.
Just give one more copy. What is there? We don't understand. Just give her a copy. Just say, when will you file reply,
My
ma'am?
lord, 2 weeks, my lord.
No, Lord, no,
It's
my
from
lord,
Bellary.
my lord,
Lord, I'll justify it. My lord, the only question
Lords, in
involved
that case,
here
my
is-
lords, I would earnestly request lordships to kindly see the endorsement which they have given. It has determinantly effect on us, my lord. They have asked us to stop mining
Just 1 minute.
activities. They have asked us to lift the.
Just one
Please,
minute.
please.
A copy of the application being 2 of 25 has been served on the counsel for the respondents who seeks a week's time. Re-notify on. This is which month? 23rd, 23rd November,
Obligement.
23rd of June,
Yes,
Monday.
Yes.
But now they, they,
I'll let you file a
this will never end. Last time a learned friend said they wanted time. I do not want to come in the way, but
It's made clear, no further time shall be granted for filing of reply.
Yes.
Next,
28.
Copy may
Next,
be given.
just give her a copy, please.
serial number 28.
the appellant.
We'll have it some other day, re-notify.
Lord, interim order granted may be extended.
Your Honor, we have two submissions, Your Honor. One is, Your Honor, we want them to file the lower court WA 267.
File an application.
Yes,
It is
Your Honor.
already filed.
And also, Your.
It is filed, we have
Your Honor,
served them copies.
specifically, there is an affidavit that is filed by the AC and the Tehsildar, Your Honor, based on which the lower court single judge had passed this order. And we still haven't found those two documents in the documents that they have submitted to the court, Your Honor. And the second thing is, Your Honor, we want notice to be issued to all respondents, Your Honor, because tomorrow they should not come and say that we were not
Please,
heard.
that ma'am, just show us the file. Who have not been served?
Lord, they had entered.
In all these appeals.
In all the
Yes,
three.
Your Honor, because
It's
we
a
were
common
caveators.
order. Common order that is challenged.
Oh. Who have not been served? Just say that liberty is counsel for the appellant to serve the unserved respondents. Okay? For the date returnable as. Do you want any documents? File an application.
Yes,
They serve on him.
Yes.
Returnable on interim order if any to continue. It's in all the three appeals or only on this?
It's
all
the three.
No, interim order, please. Interim order shall continue in WA 223 of 25 and 225 of 25 till the next date of hearing.
Your Honor, date might be given because status quo is there.
We are giving you a date. They give a date.
12/8.
And just take that map.
9/8. Much obliged.
I know, yeah, that's the reason we have issued notice now. And then interim order, we have to continue.
Past over matter.
Yes. Where is the
Past over
counsel?
matter, serial number 15.
Just call your counsel. Yes, Mr. Srivastava, what are your instructions?
Yes, madam, I got the instructions. He has no issues with the condition.
Seat is in the other court, 5 minutes.
Okay. Next, just pass over. Next. 29.
29. Serial number 29.
It's a fresh matter coming up for the first time. It's an appeal under section 37 of the Arbitration Act. I'm seeking the issue of notice to respondent number 1.
Issue notice. Just show us the file, ma'am. Notice to respondent number 2 is dispensed with being the arbitrator. Next.
My lord, may I request the trial court records to be.
What record will have? You require an arbitral record or a trial court record?
The trial court record, my prayer A in the.
No, but the arbitration record is there, was there with the trial court?
Yes, the arbitration record was
Trial
submitted.
court record be requisitioned before the next date of.
Much obliged.
18/8. Serial number 30. Sri Vasant.
I am for the appellant.
Yeah.
The application filed by the plaintiff seeking temporary injunction to restrain the defendant from changing the nature of the property and creating third-party interest came to be dismissed.
Yes. What is wrong with the order?
Lord, what has happened? The suit is one for specific performance of the offer and acceptance dated 8/4/2001, 2014, 2021. Lord, the learned trial judge, what he observes that I have not specified so far as which extent of the property I am entitled for, though I have said the Schedule B property is the property agreed to be allotted to my share.
So that's not the question. Your pleading does not indicate the date of agreement, consideration.
No, there's, my lord, what has happened? I have not actually said I have got the date of the agreement of sale. I have said that the respondents 1 and 2, being the owners of the property, they could not get the possession of the property and a record straight right from 1993. They entrusted that matter to me as I was having some knowledge about the revenue side, wherein I got this writ petition filed and the record could not be actually secured, and record missing committee, I have developed the records and other things, and I have also got the person who was in occupation of the property right from 1993 got vacated by paying certain amount to them. They say in lieu of rendering service and on the amount spent, they assured us.
What is the stage of the suit?
Suit is, my lord, now what has happened, they have filed the return statement, and return statement is at question because they filed the return statement beyond 120 days is a commercial court.
That you will argue there, not here.
But where is the contract?
Huh?
Where is the contract?
That is offer and acceptance, I have said. I produced the document. I produced the document.
What is the document?
Document is the affidavit filed by the plaintiff.
What is that affidavit?
Affidavit I have filed along with the suit.
Should have filed it. See paragraph 14.
Page 45.
Otherwise, and what is the finding on that affidavit of the learned trial court?
They just refer to that. The learned trial judge says that there is no contract and there is no consideration paid. Without what has happened is a peculiar case wherein the agreement need not always be with consideration. It is a service rendered, they have actually said it in their affidavit also.
But at this stage, when the building has come up to a certain
Well,
extent.
what has happened, when I filed the suit, there was no construction whatsoever. When the notice was issued to them, they filed Order 7 Rule 11 application for rejection of the plaint. That came to be dismissed. And thereafter they filed an application.
You filed that document, we say
Ah,
nothing. At the request of counsel for the appellant to file certain documents which were part of the trial court record, re-notify. Yes, ma'am, tell us.
6-8.
He has agreed for that 9.
My lord, even I have taken instructions, my lord. So the point is that now.
Very well, we are adjourning the matter. Just see re-notify. Ma'am, not that you have given the assurance to the court, we have asked the counsel to take instructions.
Yes, my lord.
You will not add anything to that.
Please, my lord, but inside the house, if he's given visitation, that would be helpful because the child is now undergoing treatment at Nimans, my lord, and online schooling. Nimans has told we will tell you a proper physical school. So it's undergoing online schooling. It's a special child, my lord. Now the weather conditions, the medical conditions.
Stated in the
We'll start quarreling inside the house.
Well, then again, she will file another complaint against me for so many
We
things.
will not say anything. Nothing of that sort. Only we recording your submission.
Yes,
9 would be followed.
Please, my lord.
You
But
will
not
note the
outside
last
Bangalore, my lord.
You have noted?
That if an undertaking is
Very
given, it is helpful.
What was the last line? Last line. he states, we have said, na, he will not take the child outside Bangalore. He is agreeable to that, and he also states, Mr. Srivastava, your submission we are now taking on record that you
Yes.
will not take the child outside Bangalore. Okay? An undertaking to that effect shall be filed in the court within on or before 17th of June 2025, or make it on or before 18th of June. You file an undertaking that you
And
will
my lord,
not take.
okay, I will file, my lord. My lord,
Okay.
one humble submission, my lord, that how to contact, because she has already switched off all her phone. She has blocked me everywhere.
We have
So
not
if I have
blocked
to
him.
take the
Nothing.
child,
Nothing of that sort.
all right, that is
We
submission
will
may be.
see, we have taken her statement on record.
Yes,
It is their obligation to ensure the compliance of the order.
Please, madam.
If any
yes,
violation, the necessary consequence will flow.
Please, madam.
very well, my lord, very well.
So you file it before 18 June, because the Saturday would be the visitation,
Yes.
Saturday and Sunday.
Yes, yes,
So
my
by
lord.
midweek you file it.
Yes, my
Okay,
lord.
with a
Yes.
copy to the learner council for the respondent.
Once the
Yes, ma'am.
declaration is filed, we will comply with the court.
Obviously, because this is
Please,
only a sort of notice to you. He has filed the affidavit.
Please,
with
ma'am.
the undertaking.
Please, madam.
Obliged,
Re-notify the contempt petition in July.
Much obliged. Much obliged.
And my lord, okay, all right,
21/7.
21. Obliged, my lord.
Seal number 31, Shri Murugesh Sharatu. 31.
It has to be argued.
It has to be argued.
Re-notify.
May I request for a short date, not only for
Just
this.
give it there. Next.
24/7.
Next.
32.
I appear for respondent number 3, my lord.
The short judgment may be given and final memo to say that the land has been handed over to the KIADB. It is no longer with the government.
At the,
On Thursday or Friday.
at the request of learner council for the state.
Not in existence. So I filed an amendment application, and the last petition was about to permit it to amend. I want to bring tank conservation on record instead of lake, just tank conservation.
At the request of council for the respondent state, re-notify on. Just give it, ma'am, next week. Then the council, the petitioner is permitted to file the amended memo part. You have filed it.
Filed it, my lord. It was allowed last time.
You will file it, or you will filed it?
Filed it, my lord. On the last occasion.
Ma'am, has it been filed, ma'am?
Considered, order was passed. It was allowed, order was recalled, but amendment that order was not passed. Actually, sir, the notice to 4 was not been served. Lake conservation is in no more existence. Instead of that authority, land conservation is the authority to which the function.
Have you amended the memo parties?
I filed an application at that time. The last edition.
So you carry out the amendment, no?
Not yet.
So you will carry out.
Yes.
The petitioner shall carry out the necessary amendments in view of but there is no amendment allowed.
What happened? I filed an application earlier. This was instead of respondent number 4, notice was not served because it was not in existence. So at that time the petition was dismissed, saying that it was not been served.
So you file a fresh application, no? You file a fresh application for
amendment with recalling of last order dated.
whatever you want to do it. Just file a fresh application. Re-notify.
One more, my lord.
Yes.
Regarding the prayer format. Regarding the protection of lakes, my lord, the committee headed by the deputy commissioner in the district level is the existent. They are entrusted with the function of protection and preservation of all the lakes. They cannot say that it is handed over to some other authority. As per the order, judgment of this one.
Let her get
enclosed it in. That is why
let her get instructions.
they say that it's been handed over to KIDC or whatever method, but all the lakes, it is the duty of the state government. It is the committee is there at the district level, headed by the deputy commissioner and all the members from all authorities.
Just 1 minute, just one. Ma'am, who is this respondent? Lake Conservation Development Authority.
Now the authority is no more, my lord.
The authority doesn't exist at all.
No. It's been repealed. The statute which provided for the establishment of the authority has been repealed, my lord, by amendment petition. I have filed in IA, my lord, the Gazette amended act.
No, that we have noted. Then how will you implement respondent number 4?
Respondent number 4 is the tank conservation authority is there. Lake tank conservation and development authority is there. My lord, that authority is entrusted with the
Just say
function
that
of
very well.
conservation of the lake.
Okay, we will see.
At that time, I did not know about this.
Okay.
That is why I enclosed.
Okay. Just say next week, next to next week. Re-notify.
37,
Next.
33,
Lords, I appear for the appellant in this case, my lords. I pray for a short accommodation, my lords.
Lord, I am sorry, my lord. This is a contempt filed in the month of March 24, my lord. The order relating to 2 of the persons are dead, represented by LRs, and 2 of them have retired. It is only regarding the pay and pension, my lord, because out of the 14 persons, 17 persons, 14 were given a different pay scale and 3 were given a different pay scale. Court allowed the petition, directed within 2 months it has to be implemented. The order was passed on to 23, that is 4/13/12/2023.
Just 1 minute, Mr. Joyce.
Yes.
Just re-notify after 2 weeks.
Writ appeal they have filed belatedly after this.
87.
Much obliged, my lords.
Serial number 34.
My lord, sharp date, my lord, because the petitioners are suffering.
Yes, next.
Serial number 34.
Covering for the appellant in 34.2, my lord. Pray for some time, my lord. Counsel's mother has expired 2 days ago, my lord.
The request of counsel for the appellant adjourned to
18-8.
Please, my lord.
35. Serial number 35.
35, I am appearing for respondent number 6 and 7.
Not issue, my lords. My lords, I sought for my lords payment of salary before the regional authority.
Re-notify on.
Not short date, my lords, I superannuated also, my lords. Arrears of salary, my lords.
Next, ma'am.
23-7.
Published.
Serial number 36.
There is one more letter filed by case of PC. Letter will upon 925. It also may be brought up along with this.
When is it listed? 24? Is it 920? 925 up to 24 or 900?
900.
This is our roster.
Yes, sir.
Just say that learner counsel for the appellant states that a connected appeal being 900 of 24 be listed along with this writ appeal. Full stop. If that, full stop. No, subject to the orders of the Honorable the Acting Chief Justice, list. Acha, FR number, just say FR number. Be listed along with this appeal on the next date of hearing. 37.
18-8. 37. 37.
I appeal for the appellant in this case. Lord, I have
the
been
respondent, Your Honor.
Lord, I am given to understand that my lord respondent has passed away. I'll have to
20 days, man.
bring it on record.
We have been informed that the respondent has passed away. Mr. Savakar seeks some time to file a appropriate application. Adjourned to.
File an LR application, bring the LRs on record.
You give the details of LR?
Yes, Your Lordship. In item number 37.1, I will file the impleading application. I'll also
The
show.
counsel for the respondent shall give the details of the particulars of the LRs to Mr. Savakar to enable him to file an application.
24-7. Serial number 38.
Re-notify.
Not yet filed any wakalat on behalf of.
Re-notify, just say that. No, there is, okay, wakalat not filed. Let's say that despite service, there is no presence for the respondent, re-notify on.
6/8/39, serial number 39, Ganapati, 39,
Re-notify on.
11/8/40,
Re-notify. We'll have it some other day.
28/7, 41,
We'll have it some other day. Re-notify.
6/8/42,
But I appeal for the appellant. It's 18 days delay. Subsequently, my lord, there is some urgency because the matter is relating to tender.
Speculative. They have participated in the subsequent tender and they have lost.
18 days delay.
No objections.
For the reasons stated in the application, ma'am, same order. 18 days delay is condoned. List the writ appeal on.
I undertake to file wakalat for respondent number 5, my lord.
So and so appears states that he shall file wakalat on behalf of respondent number 5. Okay, list the writ appeal on.
11/8,
Short date in July, if your lordship may.
This may
Because the
take time.
tender, then the entire appeal itself will.
Participated in the subsequent
Yes,
tender.
under protest, I
And
have
they have lost.
participated.
It's speculative.
The whole issue was the
We will
tender.
hear you. 11th August. Next.
43,
For the respondents.
Who filed the CH? Who moved the court hall?
Possibly the appellant. Will also file a reply, my lord, in the meantime.
Say none for the appellant, re-notify on.
Lordship.
Both are connected now, Mr. Nandakumar?
No, there's only one.
One now. 40, none for the appellant, adjourn to.
Lordship.
8,
44.
44,
Appearing for the respondents. 1 to 3.
Yes.
Lordship, may kindly see, they have come against the interim order passed by the learned single judge. The promotions are involved, my lord. They have obtained a stay. As the learned single judge order, they did not file any objection nor they have filed any vacating stay before the learned single judge.
Re-notify on. Just give it.
Short date may be given because.
The interim order may be extended, my lord.
21,
Interim order if any to continue.
21/7,
Short date may be given because promotions are involved. They
We have
promote,
given
my
you
lord.
July. What short date you want? Tell
Because
us.
they have already listed the persons who are eligible for
Okay.
promotion, my lord, they may promote
We will
during
look
the
into it.
pendency of the matter.
46, 45.
45, serial number 45,
None for the parties, adjourn to.
14/8, 46 urgent, 47,
None for the
47,
parties, adjourn to.
Lord, I appeal for the first respondent, Lord.
Say none for the parties. None for the petitioner, adjourn to.
7/8, 48,
Lord, we have
Commissioner.
complied with the order of this court, my lord. We have filed the memorandum of association. My lord,
48, 48.
48, my lord.
What have you filed?
A memorandum of association as per the order of this court.
Okay.
My lord, a short date.
Yes.
Aims and objectives, my lord. Page number 1, paragraph 1 states.
We will look into it on the next date.
A short date.
Next. Re-notify.
16/7, 49, serial number 40.
Petitioner, Lord, for consideration of representation.
Ma'am, what do you say? You have to file your reply?
A short date may be granted.
Re-notify after 2 weeks.
14/7, 50, serial number 50, government advocate.
My lord, I appear for
This is
respondent
that.
1.
No, not in this combination in any case. We can't even release it also. This is the same matter now which we were hearing.
No, my lord.
No.
Serial number 50
I'm
is.
sorry. My mistake.
Serial number 50, my lord. I am for the respondent 1.
We'll have it some
Has to
other
be
day.
heard.
Re-notify.
We are ready for argument and also submissions, my lord.
6/8,
We'll have it some other day.
We will
Yeah,
miss
for
your
the part,
lordship.
We wanted to greet lordship.
Lord, very happy retirement.
Very
would-
much wishes
we
to
would-
your lordship and
we would
wanted to
accuse-
say one of the great learnings for us was the erudition both on the civil side and the criminal side.
something that the bar is
Well, it's
really remarkable and very fortunate to have your lordship.
May I take the opportunity to say something with personal knowledge, my lords? We will miss his lordship, my lord Justice Srinivas Harish Kumar. It has been a sheer pleasure appearing before his lordship. We are losing one of the erudite and very astute judges. And my lords, on a personal note, I must say it is a matter of great pride that from the Chikbalapura bar, my home bar, his lordship was the first to occupy this high constitutional office, and his lordship has carried himself with great dignity and honor, and it has been an honor for all of us to have been part of this institution, and we take this opportunity to wish his lordship all the very best.
Your lordships have been Lord, an embodiment of dignity, composure. We will miss your lordships humor mix. Your lordship, we have never seen your lordships getting angry or getting mad at us. In spite of our best efforts, we will miss your lordships and wish your lordships a great and happy retired life. We would want your lordships to keep guiding us in one way or the other.
I have a vested interest, my lords. I want his lordship to join me in the Supreme Court.
A piece of composure, my lord, is departing from this court. My lord, we will be at a great loss, and we'll have an acute shortage of his lordship's presence, and his lordship will be remembered forever.
My lord has dealt in all subjects, civil, criminal, constitutional matters. Judgment tendered by your lordship will constitutional matter when the Supreme Court will confirm with a caste certificate. My lord will remember when my lord was sitting in Dharwad bench.
On
Don't
behalf
know what
of
to say. I just said thank you all. I am carrying your good wishes. Thank you all once again.
Lord, on behalf of Dharwad Bar, Dharwad High Court Bar, my lords, Lord, I thank Lord for serving the institution selflessly for such a long time. We do. Remembered for.
I remember that soon after my elevation, I was at Dharwad for 11 months continuously. That was the place where I learned the entire High Court procedure and everything. So I think I have disposed of a good number of civil appeals sitting in Dharwad.
On the criminal side, there is, my lord, a corridor statement on the criminal side on a lighter vein. Criminal law practitioners would say, whenever his lordship sat on the criminal side, appeal side, even if it's confirmation of conviction, we would take it because it is Justice Srinivas Harish Kumar who would pronounce even a conviction of holding so sweetly. My lord, we wouldn't even feel it. In fact, your lordships had a great composure. We never, my lord, saw your lordships getting at least a bit furious, even in a usual course.
We are missing you a lot.
Thank you.
We are missing you a lot.
I am grateful to all of you.
So great.
Thanks.
My lordships, I am 72-year-old. My case is pending since 13 years. I would pray for a short date, maybe the next week, 23rd, 24th. It's unsettled for 12 and a half years, almost 13 years. I retired in
We'll give you date. We'll give you date.
short date, my lord.
Yeah, give that short date. Thank you.
Computer center. 2078. ಅಣ್ಣ ನೀವು ಸರ್ಗೆ ಕೊಡಿ ಸರ್. ತುಂಬಾ ಕಲಿಬೇಕು ನಾವು ತುಂಬಾ ಕಲಿ
ಸರ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀನಿ ಸರ್ ಚೇಂಬರ್ಗೆ. ಓಕೆ ಸರ್.
Good afternoon, brother.
Shri Priyan Rajesh.
So we'll release it from parted.
Yes.
Maybe this writ appeal is released from parted. Be listed before the roster bench subject to the orders of the acting Chief Justice on. Give any date, whatever convenient.
10/7.
There is no interim order need to be continued, anything of that sort?
No, I don't think there's interim order.
That was, one is the bank guarantee was there.
That we have released, yeah.
1050, that's all.
We have complied with that.
Just show me. No, there is none whatsoever. We have not continued anything. Leave it at that. Thank you.
Great.
Thank you.
Just call the list. Release it. Just say that this writ appeal is released from parted.
No.
Be listed before the roster bench.
No, my lord, this is IA for correction.
Sorry. Oh, yes, you're right.
Lord.
It's only that now.
Yes, my lord. In fact, my lord, this writ petition was writ appeal to be withdrawn, and writ petition in fact was allowed. It was filed by the respondent.
Where is Mr. Narasimha Swamy? Because
he has been served.
That order reads as if that petition is withdrawn.
No, my lord, writ petition is filed by me, filed by the respondent against the order rejecting the application of 33(2)B by the tribunal.
Been served on this. Just check up.
It's a typographical error.
That's application.
Para 2, if your lordship sees. Narasimha Swamy, para in the beginning of the paragraph, your lordships have referred to it.
We have seen that.
Yes.
Was notice issued on this? And can we call him if he's here? Narasimha Swamy. Can you do one thing, Mr. Savka?
Yes.
Just ask your associate to just make a call to Mr. Narasimha Swamy if
Very
he can
well.
come.
Very well.
Just ask him to
Pass
come
it
so
on,
that
not
we can present,
Yes.
mark his presence.
I appear for the respondent, my lord.
Yes.
Senior counsel is engaged in another court order. Please kindly pass over this matter.
So Bhagwat has come, he has completed his arguments, but we will release it, Mr. Bhagwat.
So it was only for.
It was great pleasure to argue, but I will complete it.
Tamunda, I don't think my lord will take. Everything is heard. Advent is also given.
Can complete the reply, my lord, in 5 to 10 minutes. But
Just
I'll
say
leave it to
that
the court.
My lord, in fact, nutshell,
Not possible, Mr. Bhatt.
register the facts, everything, I think.
These appeals are released from Parthar, be listed before the roster bench, subject to the orders. Okay?
Please.
From the administrative side. There is no interim order, if any, to continue till the next date of hearing.
Please.
There is interim.
There's an interim.
I make no submission, my lord. We really miss your lordship, my lord.
Huh?
We too miss your
No,
lordship.
connected matter is there, my lord. Writ appeal 1369/23. Please club the matter.
You get it listed, once the court is decided, then you file a memo. Okay? Next. Thank you, everyone.
Great.
Same.
Interim order is to be extended.
I appeal for the impeding applicant.
Pardon, ma'am? You appear for?
Impeding applicant.
We say nothing, just say this. This appeal is released from Parthar to be listed before the roster bench, same order. Okay?
The interim order is to be.
Interim order, if any, to continue till the next date of hearing. Thank you.
Thank you.
Just go. Could you able to reach him?
Yes, Lord. It seems he was online and then said he will come online, but he says he has no objection.
Oh, he said that?
Yes.
Okay. Let's try if we can join online. Just ma'am, just call the matter once, just announce it on the.
Serial number 1, Shri Narasimha Swami.
Just say this is an application filed by the respondent Bata India Limited with the following prayer. First up, the submission of Mr. Savkar is that in paragraph number 2, comma, the words appellant shall withdraw the writ petition and raise an industrial dispute must be substituted to mean appellant shall withdraw the writ appeal.
Yes.
And raise an industrial dispute. Full stop. He states that he had spoken to Mr. Narasimha Swami,
Yes.
who has conveyed his no objection for the application being allowed. If that be so, comma, noting the contention of Mr. Savkar, comma, it is made clear that henceforth the lines in paragraph 2, in the third line in paragraph 2,
He is online, my lord, now. He has come.
Mr. Narasimha Swami, we are allowing this application instead of writ petition, it should be writ appeal.
I have no objections, my lord, as such.
Okay.
The application may be
Just
allowed,
cut
my lord.
cut that line. Just say Mr. Narasimha Swami appears for the original appellant oblique non-applicant. Has no objection if the prayer as sought is allowed. Accordingly, the third line must be read to mean that the third line which depicts appellant shall withdraw the writ petition shall henceforth be read as appellant shall withdraw the writ appeal. Full stop. This order shall be the order dated 27 February 25 in the writ appeal. In this writ appeal shall be read in conjunction with the order which we have passed in IA number 1 of 25. application disposed of. Thank you.